Come and testify. What is your name, please?
Norman Fost.
Okay, and what is your mailing address?
My home address?
Mailing address.
That'd be my work address, which is Department of Pediatrics, University of Wisconsin Hospital, 600 Highland Avenue, Madison, Wisconsin, 53792.
At this time, we request if we may approach with copies of the redacted pre-filed testimony.
Yes.
Allow the court reporter to mark the one we found. Ms. Fong, could you have the court reporter mark that first one? I think. Do you want to mark this as Exhibit A, if you would?
Exhibit A?
Yeah, or Exhibit 1.
Well, wait a minute. Now, hold on. You've got in your proposed exhibit list, you've got exhibits 1 by volume, and then you have exhibits within those volumes. So, is this something that's already in your exhibit list, or is this in addition to what's in your exhibit list?
Yeah, may I approach those boxes back to my website? Okay, so it sounds like we're at 68.
So this is a new volume,
This will be a new volume, 68.
and we'll call this pre-filed testimony?
Yes, or redacted.
But it doesn't matter. I mean, we know what the objections and the rulings were, so 68.
Is that pre-filed testimony accurate and true to the best of your knowledge?
Yes, sir.
Now, are there any changes that you wish to make before it's offered to be admitted into evidence officially?
There was one change that,
Okay.
because I forgot what page it's on.
Okay, at the top of page 16?
Yes.
Okay, and the question, and what's the question up there?
The question is for which patients in this case, and the answer was all the patients.
Okay, and what did you want to change?
I think what I intended there was all the patients who had received anti-neoplastic.
Okay. Is there any other change that you wish to make in your testimony?
Not that I'm aware of.
Okay. In tab B1, there's tabs to this thing. B1, it's a letter dated December 11, 2014 to me from you. Do you recognize this document?
Yes.
Okay, and that's, I'm going to give you what's on the very bottom of the page, which are called Bates numbers, to identify where this came from. This is Board Stamp Exhibit Volume, boy, I better know my Roman numerals today. Okay, so we're starting at Volume 1, and this is the index, the exhibits that we submitted a couple of months ago. Volume 1, the first section is actually vacant. That's page 1 through 8. Okay, so that's nothing to be omitted. The Volume 1, Section 2, FDA Regulations 21 CFR 312.7, that's base numbers 9 through 11. We're asking that that be, okay, let me go through the whole volume, maybe that's okay with you, Your Honor. Then there's the Volume 1, tab 3.
Have you heard the term that innovation always meets with resistance?
I've heard that.
And I think I asked you before we were interrupted, do you know who these people are here in the courtroom?
I didn't before you told me.
They are, in fact, patients. Most of them are patients of Dr. Burzynski. You understand that?
Yes, sir.
That it probably shows support for him? You understand that?
Yes, sir.
Do you know how many patients that Dr. Burzynski has, how many cancer patients he's treated?
Only roughly.
Do you know how many cancer patients Dr. Burzynski has successfully treated?
No, sir.
Do you know how many cancer patients Dr. Burzynski has touched with his medicine?
No, sir.
Do you know how many lives have been altered?
No, sir.
Do you know how many children have been born of people that Dr. Burzynski has successfully treated?
No, sir.
What you know is about Dr. Burzynski is what the Texas Medical Board has provided. Correct, sir?
Correct.
We have people in this room that have come from Kansas, Florida, Oklahoma, and Ohio. And now you come to us from Wisconsin. True, sir?
Yes, sir.
And Mr. Buckstein asked you for an address. And you said, I am with the Department of Pediatrics. Did I understand you correctly?
Yes, sir.
You're a general pediatrician. True?
True.
You retired in June of 2014, correct?
Retired and rehired
Rehired in what capacity?
as a professor of pediatrics and medical ethics.
All right. But you retired as a quote-unquote general pediatrician in June of 2014, correct?
Well, that was half of my job. I had two jobs, really. One is as a pediatrician, and the other is in medical ethics or bioethics.
Objection, non-response. You retired as a quote general pediatrician in June of 2014, correct?
Correct.
Since completing your formal education, you have always practiced within an academic setting, true?
No, sir.
How's that false?
I spent 2 years in the Army practicing pediatrics for the military.
All right. Treating pediatric patients, true?
Pediatric and adult patients. We were also expected to treat some adult patients during that time.
Since coming out of the Army, you went to the University of Wisconsin, correct?
No, sir. I went back to Johns Hopkins University, Johns Hopkins Hospital for some time. And
Another academic institution.
correct.
Since leaving the Army, you have always been associated in some form with an academic institution. Fair?
Correct.
All right. You began at the University of Wisconsin in 1973, correct?
Yes, sir.
You have never maintained a private medical practice. True statement?
I'm not sure what you mean by private practice. I had a primary care practice at the University of Wisconsin, which would be similar to a private practice, but it's in an academic setting.
Well, you were paid a salary by the University of Wisconsin, were you not?
Correct.
You've never gone out on your own. You've never been an entrepreneur. You've never set up shop on your own. True?
Objection multifarious. One question at a time.
I'll rephrase it. You've never established your own individual medical practice. True?
True.
You have been an employee of the University of Wisconsin since 1973. True?
Yes, sir.
A salaried employee.
Yes, sir.
In fact, I believe, and you do stand by your pre-filed testimony, do you not, sir?
Yes, sir.
All right. You had an opportunity to read it, and with the exception of page 6, one answer, you don't want to change anything. Fair?
Correct.
All right. So I can let you and I make a promise to each other. We talk about promises. You stand by this, and I can rely upon your testimony here. Fair?
Yes, sir.
Now, you say that you fashioned your education as a pathway to a career in academic medicine. Is that a true statement?
I don't quite remember that statement, so I'm not sure what that means.
Do I need to show it to you?
Yes, I'm not ringing a bell.
He's got it in front of him, counsel, just directed to where it is.
Page 2, line 7.
Is this on this pre-filed test?
Yes, sir. Yes, sir. Tell me if I read this correctly, sir. Starting after the word "and," it was a pathway to a career in academic medicine. Did I read that correctly?
Yes, sir.
All right. Now, your curriculum vitae has publications listed, true?
Yes, sir.
Now, the vast majority of the publications deal with pediatric issues. True statement?
I don't know if that's true or not. I'd have to go through it.
What did you say during your pre-trial testimony?
You'd have to direct me to that line.
I would direct you to page 3, line 43, and you tell me if I've read this correctly. The question, please identify articles in books, I think that should be or books, in your CV that you authored that concern the evaluation and treatment of children. That would be almost everything else, or at least most. So there's 150 plus publications, and probably the majority of them are about children. Did I read that correct?
Yes, sir.
You and I made an agreement that you were going to stand behind your testimony, correct?
Yes, sir.
That you weren't going to change your testimony, that was our contract, that was our promise, your promise to me, correct?
Yes, sir.
I direct you to page 4, line 1. Talking about publications. I don't think any of them are particularly or specifically about children with cancer. Did I read that correctly?
Yes, sir.
All right. Now, I have taken the time and the effort to read some of your publications, and they deal with things like genetic screening of newborns.
Okay, I'm going to object to any testimony coming from Mr. Myers.
Well, I assume that's a question, so I'll assume that he can answer if that's correct.
I'll re-ask the question. I have read some of your some of your publications, and they deal with things like genetic screening of newborns, true?
Yes, sir.
Human growth hormone administration in children, true?
Yes, sir.
Steroid use in children, true?
Yes, sir.
Childhood obesity and medical neglect, true?
Yes, sir.
In fact, that article is about potentially bringing charges against a parent for a child's obesity. It is morbid obesity. Is that the gist of that article?
Yes, sir.
Now, in your direct testimony, you reference 2 committees that you served on for the FDA, both of them being pediatric committees. True?
Yes, sir.
And we've agreed that you're a general pediatrician before you retired in June of 2014. True?
Yes, sir.
You're not an oncologist, correct?
Correct.
You're not a biochemist, correct?
Correct.
You're not a cancer biologist, correct?
Correct.
You were not trained or educated in the treatment of cancer, true?
I was trained in pediatrics, which included children with cancer at the time, but I didn't have specialty training in treatment of patients with cancer.
You don't treat cancer patients.
That's good.
Right?
Correct.
That would be outside your area of expertise, true?
Treating them would be, but
That's my question.
correct, sir.
You would agree with me, sir, that an expert like yourself should stay within the purview of their expertise. Fair?
Yes, sir.
And that an expert like yourself should be objective, unbiased, and not an advocate of a position. True?
I'm not sure what you mean by that.
Well, you're not here as an advocate for the board. Your duty and responsibility as an expert is to be objective, is it not?
Yes, sir.
All right. To look at as much information as possible and to come to conclusions based upon accurate information. True?
Yes, sir.
Just as any scientific phase 2 trial should be. Fair?
Yes, sir.
So your role here today is not, quite frankly, much different than that of Dr. Burzynski in his role as clinical investigator for FDA trials. Agree?
No, sir.
You don't agree?
Correct.
Okay. Are you acting as an advocate for the board today?
I don't know. I think I'm acting as an expert for the board.
You should be acting as an unbiased, objective expert. Fair?
Yes, sir.
But as far as your expertise with cancer, you do not have primary responsibility for treating patients with cancer. True?
Correct, sir.
You don't treat cancer. True?
Correct.
You never have treated cancer. True?
Not quite. During my residency training, I was involved in the treatment of children with cancer.
How long ago was that?
40 plus years ago.
You don't interpret genomic testing for cancer markers. True?
No, not true.
You do that.
Well, sir, I have responsibilities for oversight of research, write articles, I'm on advisory committees, review grants, and many of those involve genomic tests.
In the primary care of cancer patients, you are not charged with the responsibility of interpreting genomic testing. Fair?
Not in the primary care of patients with cancer.
All right. You don't, in the primary care of cancer patients, interpret MRIs or PET scans for cancer patients. True?
No, sir, not true.
Okay. Are you a radiologist?
No, sir.
So how is it that in the primary care of cancer patients that you admittedly don't treat, how is it that you are interpreting MRIs and PET scans with primary care?
Because patients in a modern healthcare system, like the one I work in, are cared for by many, many physicians and other healthcare providers, including consultants. And I'm frequently involved in a consultative role in the care of patients with cancer, which includes reviewing their clinical information, including imaging, MRIs, and so on. So I, in my job as a consultant in the care of patients with cancer, I unavoidably get involved in reviewing imaging data as well as other medical information.
As an ethics consultant. True?
Two roles. One would be as an ethics consultant. It's actually several ways. One would be as the main ones would be as an ethics consultant, and second, in review of research involving patients with cancer.
Review of research in what role?
Several. One, I've been chair of an institutional review board for 31 years, and that includes many protocols involving patients with cancer, which requires reviewing of a lot of medical information relating to treatment of patients with cancer.
As part of your role as an institutional review board, and I will refer to that throughout this cross as IRB. Fair?
Yes, sir.
As your role as part of an IRB, do you review patients' medical records?
Excuse me, Mr. Meyer, can I go? I just realized I gave an incomplete answer to your earlier question. Would it be appropriate for me to add to that?
Well, let me get an answer to this question.
Okay.
Because what I understood you to just say was that I have served as a member of the Institutional Review Board at the University of Wisconsin, and that I, in that role, have access to medical records and review medical records. Did I understand you correctly?
You did not.
Okay. How did I misunderstand you? Because that's what I understood you to have said when I asked you don't review MRIs and PET scans.
Well, as I recall, I said that I do get involved in reviewing MRIs and PET scans when I'm in my consultative role, is doing ethics consultations of patients with cancer. In the IRB role, I wouldn't review identifiable patient records, but I'd review protocols and plans for evaluating and treating patients with cancer, which would include proposals to get imaging procedures and so on.
Because on page 4, line 43, you specifically said, my IRB job does not involve access to medical records. True?
That's correct.
Counsel, I would say it's a usually not involved.
Yes, sir, I stand corrected. So all my involvement with medical records would be in my capacity as a general pediatrician, a child abuse specialist, and as a chair of the ethics committee doing ethics consultations. Did I read that correct?
Yes, sir.
You don't order or administer chemotherapy? True?
Yes, sir.
That's a true statement.
Correct.
You don't order or administer targeted agents? True?
True.
And a targeted agent, as I understand it, is a drug which is designed to work on a specific cancer gene or protein or pathway. Is that a fair layman's summary?
I think so.
In regards to anti-neoplastins, which quite frankly is, I believe, why we're here, you have never ordered or administered anti-neoplastins. True?
True.
You have never personally evaluated the efficacy of anti-neoplastins. True?
Not true.
You have personally evaluated the efficacy.
Yes, sir.
In what capacity?
By reviewing articles about anti-neoplastons.
Sorry, I didn't catch that. Reviewing.
By reviewing literature about anti-neoplastons, articles, commentaries, and so on.
Well, you're talking about a retrospective review of published literature.
Published literature,
I'm sorry, I cut you off. My fault.
published literature and commentaries by experts in the field at the National Cancer Institute and so on.
My question's a little different. You haven't personally been involved with the investigation and study of anti-neoplastins. True.
I don't want to mislead you. I don't personally do research on anti-neoplastons, but
That's my question.
but I was about to finish. But I have reviewed extensively a lot of the research about anti-neoplastons, so I'm pretty familiar with the design and the interpretation of that research.
You and I, you talk about promises, you talk about contracts. I'd like you and I to reach another promise if we could. Is that fair?
Sure.
I've read your pre-file testimony. I've read it 10 times. I understand what's in there. I haven't had an opportunity to take your deposition. So if I ask you a specific question, can you agree to give me a specific answer to the question?
Do my best, sir.
Without editorializing. Fair?
Your Honor, I object. That's argumentative to tell a witness you're editorializing.
I agree. Move on, Mr. Myers.
Thank you, sir. Since you're not giving standard of care testimony as it pertains to the treatment of cancer, agreed?
I'm not sure that's correct.
Why is that false?
Well, my understanding is I'm here to testify about treatment of patients with cancer, typically with anti-neoplastons and alternative therapies and consented treatment, which involves issues of what standard care would be and why people might choose experimental care. So I mean, I think the whole issue includes issues about what's standard and what's not and what's experimental and so on.
But you're not an oncologist, correct?
Correct.
You don't treat cancer, correct?
Correct.
You don't order chemotherapy, correct?
Correct.
You don't order targeted therapy, correct?
Correct.
You never ordered anti-neoplastins, correct?
Correct.
In fact, when you were asked in your pre-file testimony how you define the standard of care, you couldn't even define what standard of care was, could you, sir?
I'm going to object to the characterization. I mean,
Very specific,
Yes, sir.
point to Mr. Brown.
Line 7, line 44.
What page you
What
on?
page?
Page 7, line 44 of your pre-file testimony. You tell me if I've read this correctly, sir. Standard of care is a complicated phrase, and I don't know that there's a precise meaning of that everyone agrees to. Did I read that correctly?
Yes, sir.
On page 8, line 9, you say, actually starting on page 8, tell me if I've read this correctly. Given this ambiguity of what standard of care means, did I read that correctly?
Did you read those words correctly? Yes.
Yes, sir. So you don't know that there's a precise meaning, not everyone agrees to it, and the concept is ambiguous. Correct?
Yes, sir.
And I guess that's another way of saying that different doctors, different good and well-trained doctors like yourself, can and often do disagree about what constitutes a standard of care. Agreed?
Yes, sir.
There are different ways to treat a patient, and those different ways can all comply with the standard of care.
Sometimes.
There's not a one-size-fits-all for the treatment of any patient. True?
Well, there are some disorders for which there is a one-size-fits-all.
Okay? Different people can treat patients differently and both be in compliance with the standard of care.
In some cases, yes.
Now, on your publication list, on your curriculum vitae, and in your pre-file testimony, you were asked on page 5, any publications, and this is page 511, Mr. Buckstein's question was, do you have publications that have talked about or relate to the evaluation and treatment of cancer? You see that question?
Yes, sir.
And you referenced a couple of articles, and I went and read those articles. You have been the co-author for 2 breast cancer studies that took place in Vietnam. True?
Yes, sir.
You have also been a co-author on an article where you are developing computer programs to educate about breast cancer. True?
Yes, sir.
Do any of the patients in this case deal with breast cancer?
Not that I recall, but I'm not certain of that.
Why are you uncertain of that?
Because I've read many, many boxes of materials and lots of clinical information in there, and I can't say I've memorized all of it.
And then the other reference that you make in your answer is number 144 on your in your curriculum vitae. You co-authored with a peppercorn, and that dealt with prostate cancer, did it not?
Yes, sir.
Are there any patients at issue here in this board proceeding that had prostate cancer?
I couldn't say.
Let's talk about the FDA process. I will throughout this, I'll project things there if you need to turn, and we'll please feel free. Okay? Now I want to be sure that there's a firm understanding of the FDA process of the different entities involved in this case. Dr. Burzynski has been involved with an FDA-approved clinical investigation with anti-neoplasics. True?
Yes, sir.
And
Excuse me. There are many clinical investigations that don't involve the FDA, so they don't approve all clinical investigations.
okay, let's limit it to the clinical investigation of anti-neoplasics or drugs. Fair?
Well, investigational drugs, they certainly have to approve.
An IND. An IND stands for investigational new drug. That's what we're talking about here, correct?
Correct.
All right. And the FDA sits over everybody. They're the regulatory agency that sits over the investigation. Plaintiff's fair?
Yes, sir.
And what the FDA has to review and approve the clinical protocols, true?
The research protocols.
Which would include reviewing and approving any utilized consent forms. True?
I'm not sure that the FDA drills down to the level of approving consent forms. I believe that's largely a function of the local IRB.
The consent forms are submitted as part of the protocol approval process, are they not?
Sometimes they are and sometimes they're not. Sometimes there's just a reference to consent forms yet to be developed. I'm not certain about that.
Fair?
No, sir.
How is that not fair?
Well, I've been involved with the FDA in clinical investigations in several ways. One is certainly as an IRB member and chair for 31 years. Second, as a member of an advisory committee to the FDA, particularly on studies involving children. Third, as a member of the NIH Recombinant Advisory Committee for 4 years, which had oversight of research studies that were subject to FDA oversight, many of which involved treatment of patients, children, and adults with cancer. So my involvement in oversight of research with cancer goes beyond my IRB role.
Have you ever acted in this role? That being as a principal investigator of a cancer treatment?
No, sir.
Dr. Burzynski is in fact, of the tiers here, Dr. Burzynski, one is a clinical or principal investigator, true?
Yes, sir.
A role you have never served, true?
I have on other trials, not on cancer trials, though.
You have never been the principal investigator in a cancer trial, agreed?
Correct.
Now, the different functions is the IRB, one, they approve patients for participation in the study, agreed?
No, sir.
Why do they not do that?
They approve a protocol, the design of the study. They have little or nothing to do with the actual selection of patients.
Does the IRB not have to approve enrollment of a patient in the study?
No, sir. They have to approve criteria for enrollment, but they rarely are involved in the actual selection of patients.
I didn't say it. Did my question say selection?
You
If a patient, does the clinical investigator not have to get approval from the IRB to enroll a patient in the investigation?
As a general matter, they do, but not for a specific, well, I'm not trying to understand your question. If you're asking about recruitment of an identified,
For the qualifications of people that should be on the IRB. True.
yes, sir.
You don't have to be a medical doctor to be on an IRB, correct?
Yes, sir.
IRBs do not practice medicine. True.
Correct.
The sponsor for the this leg of things. The sponsor has many functions, but one of the functions is to develop the protocols, correct?
That's one of their functions, yes, sir.
The sponsor is also charged with reporting to the FDA, correct?
Yes, sir.
The IRB in this case is an entity called the Burzynski IRB. You understand that?
Yes, sir.
You understand that Dr. Burzynski is not a member of the Burzynski IRB, true?
Yes, sir.
All right. The principal investigator is Dr. Burzynski and/or the Burzynski Clinic, correct?
Yes, sir.
The sponsor, typically sponsors are the big drug companies, are they not?
Can you say that again?
Typically, the sponsor are the big drug companies,
That's one type of sponsor.
or the NIH.
That's another.
Those are the, if I go and look at an IND, a investigation of a drug, the majority, the sponsors are NIH or the big drug companies. Fair?
Those are the most common. There are others.
I just said that the majority are the big drug companies of the NIH, correct?
I don't honestly know whether the majority are big drug companies or not. There are many small drug companies and device companies that do research, and whether the majority are big or small, I have no idea.
The sponsor, though, in this case at least, is an entity called the Burzynski Research Institute, correct?
That's my understanding.
Which is a Delaware corporation. You understand that?
I didn't know that.
You know how many shareholders that corporation has?
No, sir.
Sponsors do not practice medicine, true?
Yes, sir.
Sponsors do not treat patients, true?
Yes, sir.
Corporate entities are precluded from practicing medicine, true?
I'm not sure I'm knowledgeable about that, but it sounds correct.
So in preparation for your testimony here today, have you reviewed the Texas Medical Practice Act?
I looked at it. I don't know if review is the word. I've not looked at the entire corpus, but I've read parts of it.
Have you, in preparation for your deposition here today, have you reviewed the Texas Medical Board rules and regulations?
Not in preparation, not specifically for this testimony today, no, sir.
Have you ever reviewed the Texas Medical Board rules and regulations?
I've read parts of them.
Did you review Rule 200?
Some are part of it, yes, sir.
Now, to be on an IRB, I think we've agreed you do not have to be in a position, correct?
Correct.
It is, in essence, an administrative position, is it not?
I wouldn't characterize it that way, no.
It has some physicians, some laymen. True?
Well, I wouldn't say that's a fair characterization. I mean, there are commonly one, sometimes two lay people, but the vast majority of IRB members are usually health professionals of various sorts, including physicians, nurses, social workers, and so on.
You don't have to be a physician to be on an IRB, correct?
Correct.
So you do have experience as a member of an IRB. You do not have experience in any way, shape, or form as a principal investigator in a cancer investigation. True?
True.
And you have never held a position in a corporation that was sponsoring a clinical investigation. True?
I'm not sure what you mean by position. I've been an advisor and a consultant to corporations that conduct clinical investigations.
A paid consultant. Correct?
Sometimes yes, sometimes no.
I mean, in this gamut here, I can cross that off, you've never done that in a cancer investigation, true?
Yes, sir.
And you've never acted as a sponsor in a cancer clinical trial, true?
I've been a consultant to companies that do cancer trials.
Okay. Were companies that were sponsors,
Yes, sir.
big drug companies.
I'd have to check my records to see how big or small it was. I don't honestly know.
Drug manufacturers.
Yes, sir.
And I think that you acknowledged on page 43 of your pre-trial testimony, line 40, page 4, line 43, that in your role as a member of an IRB, it does not involve access to medical records. True?
Generally, there
So
are.
you've already asked that question, and I already pointed out that before that you missed the word usually when you asked that question.
Your IRB, you're correct. Let me ask my next question. Your role as an IRB does not usually involve review of medical records. Fair?
Yes, sir.
Does not usually involve evaluation of medical records. Fair?
With an emphasis on usual.
And you have never been consulted about an ethical issue related to a cancer trial. True?
No, sir. False.
Tell me if I've read this correctly. Let me go to page 17, line 11 to 12. And I'm going to start mid-sentence. I get consulted regularly about ethical issues involving patients with cancer, not necessarily clinical trials unrelated to clinical trials. Did I read that correctly?
Yes, sir.
Okay, can I ask a question at this point?
You may.
Doctor, trying to understand this sentence. You get consulted regularly about ethical issues involving patients with cancer. That's, you're saying patients that are not necessarily in clinical trials.
Thank you, Your Honor, for the opportunity to clarify that. I do both extensively. That sentence is about describing my role as a clinical ethics consultant involving clinical care.
Okay, but my question is, all right, it says, I get consulted regularly about ethical issues involving patients with cancer. So we can just stop there. And then you qualify that by saying that the patients that you're being consulted about are not necessarily in clinical trials. Is that the way I'm reading that?
Right, some are, some aren't.
Okay. Okay. I just want to make sure I understood what you're saying, because then it kind of repeated itself. I just want to make sure I understood.
Thank you.
Go ahead.
Thank you, Your Honor. I want to look at Board Rule 200 if I could. Which
Could you get it a little larger?
Yeah, thanks.
Thank you.
this is one of the rules I think that you told me that you had reviewed at some point in connection with this case, correct?
Yes, sir.
And I think the board has referred to patients H through CC as quote-unquote Rule 200 patients. Do you understand? Have you seen that, or is that used?
I can't keep the letters and the correlations in my head, but
I'm not sure. I can't do it today. And I want to review some of the portions of this rule with you. And first of all, I want to review the purpose of the rule itself. The purpose of this chapter is to recognize that physicians should be allowed a reasonable and responsible degree of latitude in the kinds of therapies they offer their patients. The board, Mr. Buckstein represents, also recognizes that patients have a right to seek complementary and alternative therapies. When you review this rule, you obviously review that provision, correct?
yes, sir.
And you agree with that, do you not?
Yes, sir.
As a general proposition, patients have a right to seek complementary and alternative therapies, do they not?
Yes, sir.
I think in your publications, you refer to that as the autonomous scheme, correct?
That's part of it.
And patients are getting, the board allows a reasonable and responsible degree of latitude in the kind of therapies they offer their patients. All right. And we're providing complementary and alternate. This provision right here applies to the person providing the treatment, does it not?
It looks like it's applying to physicians doing clinical investigations, which is different from treatment.
Physicians using conventional medical practice or providing complementary and alternate medicine treatment. The people that are providing complementary and alternate medical treatment is the investigator, correct? They are the ones treating the patients. True?
Well, Mr. Meyer, you're mixing up treatment and investigations here, and they're quite separate activities. I mean, those words are used there, but it's, I mean,
Well,
there's...
Dr. Carson, I'm just saying, look at the definition. It says people who are doing the treatment while engaged in the investigation. So obviously, it starts out with saying that these are the ones that are providing the treatment.
I agree.
Is that what it says?
That's what it says. I think
Well,
it's...
that's the rule. That's what you're being asked about, the
Yeah,
rule.
I'm just trying to say it's not clearly written, but...
That's not unusual for us to deal with.
That's what it says.
Okay. What I have highlighted here would apply to the investigation. True.
I'm not sure what your question is.
Well, within an investigation, this is the rule that the board is citing to that gives them authority to attack this good doctor. Do you understand that?
Yes, sir.
And they have included multiple, how many pages of FDA documents has the board submitted?
Many.
Almost 10,000 pages. Are you aware of that?
I have no idea what the number is.
How many have you reviewed?
A lot.
Have you reviewed all 10,000?
I doubt it.
I doubt it too. And they have included documents from the FDA that apply to Dr. Burzynski as the clinical investigator. True?
Yes.
They have also included documents that deal with the IRB, which he is not a member of. True?
Yes, sir.
They have also included documents directed to the sponsor, which does not practice medicine. True?
Yes, sir.
Because the introductory sentence here, dealing with clinical investigations, it talks about physicians using conventional medical practices or providing complementary and alternative medicine treatment, the people treating within a clinical investigation is the investigator. True?
Well, as you pointed out, there are many people involved in clinical investigations. The clinical investigator is one of them. But
The clinical investigator is the only one that's practicing medicine.
well, investigation is not practicing medicine, sir. It's separate from the practice of medicine.
The investigator is the only one that is using conventional medical practices or providing complementary and alternative medicine treatment. Agreed?
Could you restate the question?
The investigator is the only one using conventional medical practice or providing complementary and alternate medicine treatment. Agreed?
Well, as I said, there are many people involved in a clinical investigation. The investigator is one of them, and he or she's certainly a very important member of that team.
I just want to be argumentative. Did you not understand my question?
Mr. Meyer, the rule speaks for itself.
Fine, I'll move on. I will move on. Let's talk about the clinical investigation process, the anti-neoplastics. Okay?
Okay.
When you were first contacted by Mr. Buckstein, you knew little or nothing about Dr. Burzynski. True?
Correct.
Did you know anything about him?
I don't think so. I mean, it's possible I heard about it somewhere else, but not that I recalled at the time.
You hadn't seen the documentaries that have been made about him?
That's correct.
You had not, to that point, you knew little or nothing about the anti-neoplastic?
Correct.
And when Mr. Buckstein first contacted you, the first thing you did is you went to the Burzynski clinic, Dr. Burzynski's website. Correct?
Well, that's the first thing that I did, and I don't remember what particular website, but I Googled Dr. Burzynski just to get some rough idea of who he was and what he was about.
And this relationship that my sophisticated audiovisual between the sponsor, FDA, IRB, and principal investigator. Many times, the sponsor is a big drug company, correct?
Correct.
Many times, the IRB is a academic institution, like the University of Wisconsin, correct?
Correct.
Many times, if not most of the time, the investigation is conducted in an academic setting, correct?
I don't know if that's most or not, but many times certainly.
Okay. So this investigation, just on its face, is different than most, is it not?
As I say,
What do you mean by this investigation? And which,
The clinical trial investigation.
of Dr. Burzynski?
Yes, sir.
Okay, I just want to establish what we're talking about.
For a question, I apologize.
All right.
The clinical trial investigations, the clinical investigations of anti-neoplastics is different than most in that we don't have a big drug company. We don't have an academic institution acting as the IRB. We don't have an academic institution acting as the principal investigator.
Objection, that's a multifarious
He
question.
can answer. No way he's going to the question.
I don't know about the most part. I have no idea whether most trials are big or small, or big companies or little companies.
I think the question was, you don't have any of those in this case.
That's correct.
I don't know if that was the question. That's a good question. Thank you.
All right, that's the question I wanted to answer.
That's a question I wanted to answer too, so I thank you. Back, I think you say in your pre-trial testimony, this is a unique set of facts, correct?
Yes, sir.
That you have never seen a situation like this, true?
Yes, sir.
But it was an arrangement that was approved by the FDA, was it not?
Well, I don't know what you mean by arrangement. The FDA approves the proposed trials. I don't know that they approve the arrangement by which the Burzynski clinic works, the relationships between the institute, the clinic, Dr. Burzynski, the IRB. I don't know whether all of those things are approved by the FDA. Their main job is to approve the proposed clinical trials.
Yeah, but they look at documents submitted by the IRB, they look at documents submitted by the sponsor, they look at documents presented by the principal investigator, and then the FDA says, yea or nay, you can proceed. Fair?
Well, Mr. Marsman, you said, referred earlier to my comment that this was unique. One of the several things that was unique about it, or that is unique about it, is the unusual conflicts of interest in these relationships. I don't know that the FDA generally gets involved in conflict of interest management or in arrangements of clinics and institutes, sponsors, and so on. That's not usually what they're reviewing when they review those protocols. So that's what I meant by referring to the uniqueness of it, and how much the FDA gets involved in that is it's not usually their province. It's usually other entities that look into those issues.
But ultimately, whatever the FDA did, you don't know what the FDA knew or didn't know. I'm assuming, nor do I. But ultimately, the FDA approved the clinical trials. And they said, Dr. Burzynski, you as principal investigator, Burzynski Research Institute as sponsor, and the Burzynski IRB can proceed with the clinical investigation of the anti-neoplasm. True?
Yes, sir.
Now, the National Institute of Health, who is oftentimes the sponsor, in addition to big drug companies, are you aware that they actually developed the first protocols for anti-neoplasms?
Am I aware that they developed the first protocols for anti-neoplasms? No, I'm not aware of that.
And that Dr. Burzynski then took over the NIH, National Institute of Health, initial protocol for this study. You didn't know
Larry
that?
just said he wasn't aware that NIH did it, so how could Dr. Burzynski take it over? He just said he wasn't aware that NIH had done the initial protocol, and then your question was that Dr. Burzynski had taken over from that initial protocol, but he just said he wasn't aware of it.
So he's not going to be aware of this.
So how can he be aware of what he took over?
Well, I'm trying to establish what he
I
knows.
understand that, but I'm just saying the way you asked it, you're asking him to build on something that he says he doesn't know.
He didn't know the first time, he's not going to know the second time.
That's correct.
No, I understand. How many different protocols has been developed by the anti-neoplastic sponsors in this case?
I don't know.
You haven't seen in the literature that you, or the materials that you have reviewed, that there are, in fact, been 72 FDA-approved protocols for the study of anti-neoplasms.
I may have come across that. I didn't recall the number.
And there, the way I understand it is there has to be a separate protocol for different types of cancer, different types of patients. Fair?
Not necessarily, no.
Do you know in this case what the different protocols are?
I've read some of them. I probably haven't read all of them.
You read any of them?
Yes, sir.
Which one?
I can't recall if I don't know how you want me to refer to them. If you show me one, I'll try to tell you whether or not I read it.
Well, I'm asking a more general question. My question is, what protocols have you reviewed? Of the 72 that have been approved by the FDA,
I don't
do you know which one?
I don't know how you want me to refer to them. I mean, I don't remember their numbers. I don't remember their exact titles. If you show me a protocol, I can tell you whether or not I reviewed it or not.
Well, I don't have all 72 sitting here with me. I have to. If you don't know which ones you reviewed, fair?
I don't keep them in my head, no.
What types of cancer were they for?
They were for several different types of cancer.
Which types?
Some of them were about brain cancers. Those are the ones I recall most prominently.
Okay. At the very end of your pre-trial testimony, you talk about a patient J, correct?
I don't keep the letters in my head, sir, so I don't know which ones I
Go up
commented.
to the specific part of the testimony, Mr. Parners.
I'm jumping ahead, so I think it's about page 60-ish. It's actually page 62, Your Honor.
Okay.
Your Honor, if I might help, I think it doesn't start talking about patient J until page 62.
That's what you just said.
I think I just said that.
Thank you.
Did you review the protocols for patient J?
I think so, yes.
All right. Then what I'd like to do, I would like to question you in the order that you have submitted your pre-trial testimony. So I'm going to get there at the end. But I just wanted to establish that one of the protocols that you have in fact reviewed is for patient J, correct?
I believe so.
All right. Now, protocols are very detailed documents, are they not?
Yes, sir.
I think the protocols in this case, each and every one, is something on the order of 150 pages. Does that comport with your recollection?
It sounds correct.
All right. The protocols detail and are very meticulously detailed, quite frankly, the steps that have to be followed in conjunction with the study. Fair?
Yes, sir.
And the FDA is the one in this relationship here that approves the protocols. True?
They're one of the approving entities. There are others, the IRB being one of the most prominent.
Protocols are developed by the sponsor, approved by the IRB, and ultimately given their blessing by the FDA. True?
Well, ultimately by both or more of those entities.
Right. The FDA has given Dr. Burzynski approval to do clinical trials on anti-neoplasms. True?
Subject to approval by the IRB.
Okay. Well, the FDA is the ultimate decision maker, are they not?
They are not.
Why not?
because the ultimate decision maker is the local IRB. The FDA can approve a trial, and an IRB can refuse to approve it, and the trial will not go forward.
In this case, the FDA has in fact approved clinical trials for the study of anti-neoplasms,
Subject to the approval of an IRB.
which has been granted, correct?
Yes, sir.
The FDA or someone must have made a determination that these potentially revolutionary products were worth investigating. Agreed?
Yes, sir.
And you bring up conflict of interest. And that Dr. Burzynski is the principal investigator, and that he also holds a stake in the corporate entity that is his sponsor. And you testify in your pre-trial testimony in general terms that that's a potential conflict of interest. Fair?
Yes, sir.
And whether the FDA has looked at that issue or not, you don't know one way or the other. Agreed?
Yes, sir.
But what the FDA has done is they have approved and sanctioned the parties that are involved in the investigation, that being the IRB, the sponsor, and the principal investigator. True?
Well, I'm not sure the way you said it is quite true. As I said, the ultimate sign-off to allows the study to go forward is a duly constant IRB approving it. And that's a key point here, because that didn't happen with regard to patient J, as I understand it.
Patient J didn't have his protocols approved?
By a duly constituted IRB acting in a proper way.
Let's get to patient. We'll get to patient J then, I promise. Okay? But your conflict of interest, I think, involves, or at least as I understand your testimony, involves Dr. Burzynski acting as the principal investigator, correct? Under Rule 200.
Well, that's just one part of it.
I understand, I'm getting there. My question is talking.
Mm-hmm.
And his role as the sponsor.
That's
With the sponsor.
That's another part of it. You left out another part of it.
Well, I guess my point is, all areas of life, all areas of medicine have potential conflicts of interest in them.
Yes, sir.
If I go see a spine surgeon, that surgeon potentially he has an interest in performing surgery on me, does he not?
Yes, sir.
I'm a lawyer. I get paid by the hour. I guess I have an interest in taking a long time to do so. I mean, a conflict of interest is not something new in any profession, is it, sir?
Correct.
And conflict of interest is not something that is unique to a clinical investigation.
This clinical investigation was unique in my life experience. I've never seen or heard of anything like this.
Well, I think you said it. You said I've never seen this unique set of facts. True.
Yes, sir.
But what the rules of ethics require is that the physician do his best, correct?
Yes, sir.
What the rules of ethics require is that the doctor use his or her best clinical judgment to do what he believes is in his patient's best interest. True?
Well, that's a misleading representation in this case. If the clinician is just acting as a clinician, and you've left that off this chart here, that's a fifth operator. Dr. Burzynski is not only involved in some of these other activities, but also as the patient's clinician. And part of the conflict, one of the most important conflicts here, is the conflict between his duty as the patient's doctor on the one hand, and as an investigator on the other, and as the owner or director of the sponsor. So he's got 3 conflicts of interest, and that is frankly something I've never seen or heard of before. And somebody operating in those 3 roles.
Dr. Burzynski, and I promise you we're going to get there. But Dr. Burzynski is the principal investigator, and then have you seen the chart that is in that evidence that delineates the different roles of the different folks that Burzynski plays?
I think I have.
And then under Dr. Burzynski, each patient, do you understand, is assigned a board certified oncologist. Do you understand that?
I understand that an oncologist was supervising some other intermediary professionals.
I promise you we're going to get there. But ultimately, what a doctor has to do in his treatment of patients, I don't care if it's in private practice, academic setting, in a clinical trial, he has to evaluate the patient's clinical condition, evaluate the patient's diagnosis, and based upon his training, education, and experience, do what he believes is in the best interest of the patient. Agree?
If he's
a general concept.
If he's acting solely as the patient's clinician.
Talking your pre-trial testimony on the exorbitant costs that are involved with clinical investigation. These things are unbelievably expensive, are they not?
Usually, yes, or commonly anyway. Not always, but usually. The new investigational drugs.
I mean, I think, if I'm not mistaken, that one of their functions.
Yes, sir.
Are you familiar with literature that has been written in which it claims that the FDA discourages and often bans drugs that might compete with approved drugs?
What's the question? Am I
Have you reviewed literature that discusses that aspect of the relationship between the FDA and drug?
That statement that you just read or quoted is just an oversimplistic generalization that so I've read lots of literature about concerns about the FDA and the regulatory process, whether it goes so far as whether the sentence you read is.
Well,
I've not read that specific sentence. No.
You share those concerns too, do you not, as evidenced by your written literature? Correct?
No, sir. I think the FDA does a very good job in reviewing drugs and the drug approval process.
But they have a federally inspired concern with minutia and punitive sanctions. You wrote that, true?
Correct.
They have narrow interpretations of every word in a regulation. True?
Well, that refers
You
to.
wrote that.
Yes, sir. Yes, sir. But it has nothing to do with the issues in this case, as far as I can tell.
Now, on page 18 of your pre-trial testimony, on line 7, talking about the ethical and responsibilities for patients that treat adults versus children like yourself, you acknowledge that there is a slightly different ethical standard. That's page 18, line 7, correct?
Correct.
And you explain that difference in describing the adult standard as on 18, line 12, as an autonomy standard, correct?
Correct.
On 18, line 27, you say the duty with the adult is to try to respect that person's autonomous preferences. Did I read that correctly?
Yes, sir.
In other words, that person's right to choose. Fair?
That's part of what autonomy is about.
Their right to try. Fair?
Well, as a gross oversimplification, yes, but it doesn't really get at the key issues.
Well, are you familiar with the Texas right to try legislation?
I'm familiar with efforts by many states to pass right to try. I'm not familiar with the specific Texas example. I'm familiar with the general concept, and I've seen proposed statutes in other states. I haven't seen Texas version of it.
Dr. Bass, I'm going to remind you just to listen to this question and answer just that question.
Thank you, Joe. I would offer into evidence, Your Honor, a portion of the Health and Safety Code, the Texas Health and Safety Code, section 489.001, which is also known as the right to try legislation.
I'm going to immediately object to this. Law wasn't in effect at the time of any of the events in this case.
Statutory authority and rules that govern this proceeding are already part and parcel of this proceeding. It's not necessary to admit I mean, all you need to do is refer to the statute, and any statute that may affect this case can be brought to our attention. Articles 159. If you happen to have an extra copy to get before her, it would probably be easier for her to follow.
I promise you I will give you copies. How many states have right to try legislation?
I don't know the number.
Right to try legislation generally refers to statutes, and in this case Texas, that gives patients a right to try alternative type of medicines and treatments. Fair summary?
Yes, sir.
And this is from the Texas statute. It gives the right to try to patients with terminal illness, which it is defined as without life-sustaining procedures will soon result in death or a state of permanent unconsciousness from which recovery is unlikely. Did I read that correctly?
Yes, sir.
And an investigational drug is defined by the right to try legislation that has successfully completed phase 1 of a clinical trial, but has not yet been approved for general use by the U.S. Food and Drug Administration and remains under investigation in the clinical trial. Correct?
That's what
Did
it
I
said.
read that correct?
Yes, sir.
That definition would apply to anti-neoplasms, correct?
Presumably.
Under the Texas legislation now in effect, Dr. Burzynski is completely authorized to prescribe anti-neoplastics to terminally ill patients.
Okay, I'm objecting. He just called for a legal opinion. We haven't offered this witness as an expert in legal.
And just for the record, the statutes that you've been referring to, I understand you've indicated it became effective recently, but the date it became effective
June
is June 2000.
Yes, ma'am. You're not a lawyer, correct?
Correct.
You're not offering legal opinions in this case, correct?
Incorrect.
Okay. All of the patients in this clinical investigation of anti-neoplasms had a terminal illness, did they not?
I don't know the answer to that.
Is that because you haven't reviewed all of the patient's records?
That's one reason.
What's the other?
I didn't look at the direct records. I mean, I looked at partial pieces of records. I didn't make a personal evaluation of what the patient's prognosis was.
Fair. You looked at the records that Mr. Buckstein provided you.
That has been discussed.
I think we can all stipulate in this room that that cancer is a terrible disease that has probably affected each and every one. True? Including yourself.
I don't know what you mean by each and every. No, I'd say no if I have to answer briefly.
Cancer is a terrible disease. The answer no to that?
Sometimes not so terrible.
And maybe more than any other area of medicine, the treatment of cancer is evolving. Agreed?
Yes, sir.
The treatment of cancer is changing, correct?
Yes, sir.
The standards that are used in the treatment of cancer changes on a yearly basis, does it not?
Yes, sir.
In fact, the NCCN standards are amended on almost a yearly basis, are they not?
I don't know how often they amend them.
The standard regimen has typically been radiation, chemotherapy, and surgery. True?
Correct.
What Mr. Cogdale referred to as the burn, cut, and poison method. Have you heard that term?
I heard it this morning.
First time?
I've heard variations of it.
Agents that were once considered standard today may not be. Agreed?
Yes, sir.
Things which will be considered standard in the future may not be today. Correct?
Yes, sir.
Now, all drugs are potentially harmful, are they not?
Yes, sir.
Particularly cancer treatment drugs. Fair?
Yes, sir.
There's not a single drug that doesn't carry risk. True?
Yes, sir.
Cancer treatment drugs in particular can be very toxic, can they not?
Yes, sir.
They can cause many different side effects. True?
Yes, sir.
They can cause many different adverse events. Correct?
Yes, sir.
They can cause serious adverse events. Agreed?
Yes, sir.
Cancer drugs in and of themselves even can cause death from the administration of the drug as opposed to the disease itself. True?
Yes, sir.
And that's true whether the drug has been FDA approved or has not yet been FDA approved. True?
Yes, sir.
That is true even when cancer drugs are used on label versus off label. True?
Yes, sir.
Mr. Meyer, for the benefit of the court, can you explain your terminology?
On label, no flavor. That's exactly where I'm going. Thank you. Even when cancer doctors, good and well-trained cancer doctors like Dr. Burzynski, use standard therapies, the patients can still have adverse events, serious adverse events.
I'm going to object to a characterization of something that's not in evidence that Dr. Burzynski is well-trained.
You want to rephrase your question?
I will. Are you here today to criticize Dr. Burzynski's training?
I don't think so.
Doctors can use standard therapies and still obtain unwanted toxic events or adverse events. True?
Yes, sir.
I mean, I've seen it read that the treatment can be worse than the disease itself. Have you seen that?
Yes, sir.
And on page 21, line 15,
Give us a second.
yes, ma'am. Got it?
Go ahead.
Talking about competing points of view. If you have a uniformly fatal condition, then it was justified to expose the patient to more serious risk of harm or even the risk of death from the treatment because he or she was destined to die anyway, so you had nothing to lose. Did I read that correct?
Yes, sir.
Your Honor, I'm going to make the basic objection that counsel is repeating statements in the pre-filed testimony, taking up time doing that when this witness has already said he adopted this pre-filed testimony. It's true and correct. So going through it and saying, am I reading that correctly? If that's what's in the pre-filed testimony, what's the necessity of all these questions like that?
I'm going to overrule your objection because it's cross, but I will note that this is already correct.
Kind of damn it. And just in brief response, I think he's contradicted his pre-filed testimony multiple occasions thus far. So I want to be sure that we're on the same page.
Go ahead.
Thank you. Now, one of the evolving areas of cancer, and I promise I'm getting to on-label and off-label too. Judge today's.
Yeah, before I forget it, so.
Yes. I wanted to be sure you knew I had forgotten. But one of the evolving areas of cancer treatment is something called targeted therapy, correct?
Yes, sir.
I think it's also referred to as gene-targeted therapy, correct?
Yes, sir.
And I even have seen literature, and I know you discussed in your pre-filed testimony, it's called personalized treatment or personalized approach. You've seen that term before, haven't you?
Yes, sir.
And I think the theory behind targeted therapy is that if we identify certain genes or proteins, which are the products of genes, which are typically found with particular types of cancer, and we use a drug that selectively attacks that gene, protein, or metabolic pathway, and we could potentially get selective treatment of that cancer. Is that the general theory behind that?
Yes, sir.
All right. And I think on page, well, I'm going to refer to it. That's, I believe, you believe that that's a very, a lofty goal, correct?
Yes, sir.
But I think you referred to it as, we're just not there yet, it's a fantasy. That's your opinion, correct?
That's a out of context statement, so it's only partially true.
Well, targeted therapy is a therapy that cancer doctors use in the treatment of cancer, correct?
Yes, sir.
On page 22, we start talking about patients A through F. And I want to talk to you about them. Did you review patients A through F's medical records?
As I said, I don't remember the letters, but I believe so.
All of the medical records or select portions?
I read most of the materials that were provided.
Would you agree with me that all patients A through F had very serious cancers?
As I recall, yes.
All patients A through F had very advanced stages of cancer. True?
I don't remember enough about the details to answer that.
Okay. All of the patients A through F had what would be termed universally fatal cancers. True?
I don't remember enough about the details to answer that.
I think patients A through F consisted of pancreatic cancer, liver cancer, brain cancer, mesothelioma, kidney cancer. Does that comport with your recollection?
Sounds familiar. not all of those are uniformly fatal.
Well, most of the patients A through F, I think with the exception of one, had tried standard or conventional therapy that had failed. Does that comport with your recollection?
I don't remember the details of A through F to be able to answer that confidently.
Fair. Are you aware that virtually all of Dr. Burzynski's patients have a universally fatal cancer diagnosis?
Don't have enough information to answer that.
Are you aware that virtually all of Dr. Burzynski's patients have cancers which are difficult to treat?
I would say most, if that's what you mean by virtually.
Okay, I'll phrase it as most. That most of Dr. Burzynski's patients are patients that have very poor prognosis.
Yes.
That most of Dr. Burzynski's patients are patients that have failed standard therapy. True?
I don't recall the proportions. I know some did and some didn't, so I don't know the proportions.
And you understand that Dr. Burzynski has dedicated his professional life to treating these types of patients. You understand that?
In part, yes.
That's an admirable trait, isn't it, sir?
Yes, sir.
It's a trait that should be recognized and pursued and not vilified.
Whether it's vilified depends on how he goes about it.
Now, I think you say on page 22, line 29, or 29 to 32, the patients A through F, there is no claim that they were part of the clinical studies. Correct?
Yes, sir.
And all of these patients, patients A through F, does this comport with your recollection? They were treated by what are called these targeting agents.
You want me to answer that?
Yes, sir.
Well, I think you're using the word, I think the word targeting can be used in 2 or 3 different ways. And I think you're mixing some of them up by making it sound as one thing. I mean, the most trivial way of using that term is all treatments of all patients is targeted. We treat patients one at a time, we look at their condition, and we try to target the treatment at whatever that patient has and what's likely to work best. That's a trivial use of the word. Second, there are drugs, particularly in cancer, that have been created in response to, let's say, certain proteins that cancers make, and that are given.
Your Honor, can I object to non-responsive? I think it was a yes/no answer.
I could be asked if you wanted him to respond. I don't know.
But I think the question was, these patients have been treated with targeted agents. Yes or no? Or I don't
allow the
know.
witness to answer the question.
Thank you.
A second use of the word targeting is researchers develop drugs that are meant to attack or defeat specific proteins that a cancer may have. That is, they're targeted at a specific protein, but may be given to dozens or hundreds of patients who have a cancer that exhibits that protein. The third way, and the way in which I think it's used in contemporary discourse, is to do a specific genetic test on a specific patient, on his or her specific tumor, and to develop a therapy or find a therapy that's targeted to that individual patient based on a molecular analysis of what his or her tumor is. I did not have the impression that was what Dr. Burzynski was engaged in, and certainly not all of the patients. As far as best I can recall, not most of them.
Let's go to off-label use of drugs. Let me see if I can explain what off-label is, and you tell me if I've done an adequate job. when drugs go through the FDA process, they are approved for a particular purpose. And that is what I refer to as on-label use. Fair?
Yes, sir.
Off-label use is when an FDA-approved drug is used for a purpose for which it is not approved. Fair?
That's partly what off-label means.
Off-label use, using an FDA-approved medication in a way not approved by FDA label.
Yep, that's better.
Is that better? Okay. The off-label use of drugs is allowed, is it not?
Yes, sir.
I think, and this is where the court may have to bear with me, because I think this was admitted under a different number than I'm cross-referencing to, but it is Dr. Fost's literature entitled Ethical Dilemmas in Medical Innovation and Research, Distinguishing Experimentation from Practice. I believe.
It was attached, I believe, to.
I think it's volume 61, page 45143, if I'm not mistaken.
We're gonna, get in the focus documents, that's the number on it. We're gonna have to correct that, of course, because it seems like we got off on numbers. But 45143 is the correct number in focus
On the
documents.
focus documents, it's under tab.
61.
Yeah, I knew I was going to run into this when
That's
numbers
all right.
started
It's
changing.
on, just so we're all on the same page, it's under tab B3.
All right. Are we good?
Yes.
Thank you, sir. This was an article written by you, correct?
Yes, sir.
Right here, what I've circled. Much of standard practice involves interventions that have never been adequately tested for safety or efficacy. Did I read that correct?
Yes, sir.
Down here. The Food and Drug Administration does not prohibit or discourage physicians from using drugs for unapproved purpose. The FDA regulates the suppliers, not the prescribers, and accordingly restricts marketing practices, not use. Did I read that correctly?
Yes, but out of context. Go ahead.
The FDA does not prohibit the off-label use of drugs, correct?
Yes, sir.
Down here. The Food and Drug Administration regulations explicitly allow approved drugs to be used for unapproved purposes if the intent is to benefit the patient.
Mr. Myers is getting the off-label use is permitted.
Got it. We're in agreement.
Yes, sir.
Patients Patients A through F were treated what I want to refer to as targeted agents, but they were treated with drugs that were off-label. Is that fair?
I don't think so.
Why is that not fair?
Because you're using the word targeted in the trivial sense. The way in which it's used in contemporary oncology today refers to a much...
Hold on. I believe your question was that these patients were being treated with off-label drugs.
That's
that
correct.
were then approved.
That is my question.
That's his other question.
No, excuse me, Your Honor, but he used the word targeted.
Well, then I'll ask
He
you that.
withdrew that and
Oh,
rephrased
I'm
his
sorry, I
question.
missed that.
So please listen to his questions and just answer this question.
Patients A through F were treated with the off-label use of medication.
Yes, sir.
Patient B in particular was at one point treated with anti-neoplastic, correct?
I don't remember specifically, but I'll take your word for it.
He is the patient that was in Germany that his German physician was treating him, and the anti-neoplastics were shipped to Germany.
I'm going to object to a characterization of things, they're not in evidence anyway yet, except as what's reflected in the medical records. Mr. Myers saying what those means is not a source for testimony. It's Dr. Fost.
It's in your second amended complaint under notes of each, what you claimed about each patient, and that is something that you
Yeah.
refer to in your complaints on your objections that were. Go ahead.
Thank you. And the FDA rules explicitly allow Dr. Burzynski to ship to Germany, do they not?
I don't know the FDA rules on shipment to Germany.
Well, on page 29, line 35, you say, I also believe that FDA rules prohibit interstate commerce involving unapproved drugs, so shipment outside of Texas would constitute a violation of that requirement.
Excuse me, what line are we on?
Page 29, line 35.
What was your question?
My question, well, I think he just contradicted himself.
Is
So
that
my
your
question
question?
is, so I will get to my question. Thank you, Josh. So now what I understand you to be saying is you don't know what the FDA rules prohibit and what they don't. Fair?
Not entirely, no. I think the word prohibit there may have been poorly chosen. It should have, what it meant was they regulate, they can, they may prohibit, they regulate interstate commerce.
But whether they have explicitly allowed shipment of anti-neoplastons to Germany or not, you don't know one way or the other.
That's
Fair?
correct.
And then, do you have any, have you seen any of the billing records for any of these patients?
Very briefly, I didn't spend much time devoted to that. I didn't think it was my area of expertise.
Do you have any evidence that Dr. Burzynski was charging for anti-neoplastons?
I don't have an opinion on that.
In your pre-file testimony on page 29, line 38 to line 42, you were asked whether you had an opinion on that, and you said, I do have an opinion. The question was, do you have an opinion whether Dr. Burzynski's lack of compliance with the protocols of the anti-neoplastin studies related to charging for anti-neoplastins and exporting anti-neoplastins with regard to patient B constitute a violation of ethical and professional responsibilities as a physician involved in a clinical investigation? Your pre-file testimony said yes. Correct?
Correct.
So now what you're telling these judges is, I haven't looked at the billing records, I'm not an expert on that issue, and I can't give that opinion. True?
Not true.
Well, what evidence do you have that he was charging for anti-neoplasms?
Your Honor, this is Mr.
What's your
Myers.
objection?
I'm objecting. This is Mr. Myers confronting the witness and requiring somehow that he has everything memorized instead of saying, look, let's look at the patient B records and show me what we're
Overruled.
talking.
And I'd like your objections not to be running objections, just state what it is and let me rule on it. Otherwise, the hearing's going to take a lot longer. You
Thank
may
you.
proceed.
Thank
This
you,
is
Your Honor.
Cross. This is an expert. It's not a.
Do you have any evidence that Dr. Burzynski was charging for anti-neoplasms?
And now, refreshing my memory, yes, apparently I did.
What evidence is that?
I saw some bills.
Can you point the court to those bills at all?
I don't have any of that in front of me, no, sir.
And whether the FDA I didn't know. Withdraw the question. On page 35 of your testimony, we start talking about FDA issues. And I think to be fair, my understanding, and tell me if this comports with your understanding, is that the FDA patients involve really patients G through CC. Does that comport with your recollection, or you don't know?
I don't know.
What I'm going to refer to is the Rule 200 patients, okay? Because that's the way the board refers to them in the second amended petition. Fair?
Okay.
The Rule 200, which we agreed applied to the medical treatment to the investigator. Fair?
I don't understand the question.
Move on. Now, you've reviewed some of the patient's records, G through CC, but not all of them. Is that what I understand?
I don't remember which patient records I reviewed.
Well, let's talk about anti-neoplasms. They are the subject of the clinical investigation. You do understand they were discovered by Dr. Burzynski, correct?
Yes, sir.
Now, Dr. Burzynski at the time of discovery was actually a professor at the Baylor College of Medicine. Did you know that?
Yes, sir.
I think you told me that you did not know that the NIH developed the first protocols for anti-neoplasms, correct?
Yes, sir.
And as clinical investigator, Dr. Burzynski subjects himself to the FDA, correct? FDA oversight.
He should.
He is bound by what you term the federally inspired concern with minutia and punitive sanctions, correct?
No, sir. No, sir. Incorrect.
He's bound by the inflexible requirements of adherence to narrow interpretations of every word in a regulation. Correct?
No, incorrect.
Well, I'm using your terms that you wrote in that article.
Sir,
I'll go on. He is bound by an entity, a regulatory entity that by your own terms has gone too far, correct?
in other cases, yes.
And you have agreed to, I believe, that perfect compliance with FDA regulations is not an attainable goal, correct?
Yes, sir.
Now, I'm struggling with how to go through these FDA because I think there are roughly 10,000 pieces of paper that deal with the FDA that were exchanged between Dr. Burzynski and the FDA, or the IRB and the FDA, or the BRI and the FDA. Does that comport with your recollection? There was a lot. Can we agree there?
Yes, sir.
All right. And Respondents Exhibit 5 in regards to anti-neoplasms are pertinent, is entitled Pertinent AMP Articles and Presentations authored by Stanislaw Burzynski, PhD, MD, PhD. And on that document there are 74 articles that Dr. Burzynski has written and published on anti-neoplasms. Have you seen this document, Exhibit 5?
Yes, sir.
And have you read all 74 publications?
No, sir.
And just so we're clear, the FDA does not preclude Dr. Burzynski from publishing on his studies. True?
Yeah, correct.
As Exhibit 6 is entitled, this is Respondent's Exhibit 6, Your Honors, Selected A&P, anti-neoplastic, articles and presentations authored by other authors, and that lists 44 different articles. Have you seen Respondent's Exhibit 6?
Yes, sir.
And have you read all 44 articles?
No, sir.
And there have been articles and presentations authored by others in regards to anti-neoplastons other than just Dr. Burzynski. You've seen that, correct?
Yes, sir.
All right. Respondent's Exhibit 137 are 12 articles that were written by a Japanese physician, Hideki Tsuda, MD. Have you seen this document?
Yes, sir. I don't know if I've seen that document, but I've seen other articles by Dr. Suda.
And have you read all 12 of Dr. Suda's articles?
No, sir.
Respondent's Exhibit 133 is entitled Case Histories of Patients Treated with Personalized Targeted Therapy for Brain Tumors at the Burzynski Clinic. Have you seen this document?
I can't see it from here, but it sounds familiar, and I believe so, yes.
Would you like to see it?
No, sir. No need to.
And all of these publications and case histories, 133 and the others, 137, 6, 5, all respondents exhibits, address anti-neoplastons and the results that had been obtained through the clinical trials, correct?
I don't know. I don't have them all in front of me.
You haven't looked at them all.
I've looked at them, but I don't memorize what's in them.
Let me talk about FDA inspections. As a member of an IRB, which you presently are, correct?
No, sir.
Did you retire from that role as well?
Yes, sir.
So you're no longer a general pediatrician and no longer on the IRBs?
Correct.
So your sole practice today is acting as an ethic consultant on an as-needed basis. Fair?
I don't know what you mean by as needed. I work on a regular basis.
When did you discontinue your membership on the IRB that you were a member of?
About 10 years ago. I'm not sure of the date.
So the time period in question here really deals with patients that were seen and treated from about 2010 to about 2012. Is that comport with your recollection?
Sounds familiar.
Sound fair? So during that time period, 2010 to 2012, 2013, you weren't even a member of an IRB, were you, sir?
Correct.
As a member of an IRB, have you ever been subject to an FDA inspection?
Yes, sir.
On how many occasions?
That's a guess, but 5 or 10 maybe.
Nerve-wracking process?
Challenging.
Very tedious process, is it not?
Requires a lot of work.
I agree. And what percentage of FDA investigations result in deficiencies against the entity or person being inspected?
I don't know.
Majority?
I have no idea.
Do you know that the most common findings when an investigation is conducted by the FDA include protocol noncompliance, inadequate records, inadequate drug accountability, informed consent issues, and adverse event reporting?
I'm going to object that that's evidence that that has happened. That's the way the question was stated. Did you know that something exists?
Mr. Myers, could you rephrase the question, because I don't remember exactly what you asked? I apologize. And I'll just ask that you speak up a little bit because you're away from the mic.
We have to plug it.
Ah,
It's the first time I've ever been accused of not being able to be heard.
I'm behind you, Mr. Crock. You're looking the opposite direction.
Is this better?
Yes, if you just tilt your face a little bit towards us, I think it would help. But if you could rephrase your question, I'd appreciate it.
When FDA investigations are done, do you know what the most common deficiencies found are?
No, sir.
Now, you can go to the FDA website, though, can you not? And see a yearly summary of warning letters, correct?
I don't know if they're yearly summaries, but you can see warning letters, yes.
Your Honor, it's getting past 2:30. If we could just figure out where we're going, at what point we're at, whether we're going to be done by 5 o'clock or something.
Well, we've only been going an hour since we've come back from lunch, so I think we need to press on for a little
Yeah,
bit.
Your Honor.
Okay.
I'm not asking for a break. Thank you.
I'm sorry, what?
Well, we weren't asking for a break. We were just trying to figure out where this is going, because it sounds like they're deposing the witness instead of cross-examining. I mean, the questions keep.
Unless you have an objection, let's let Mr. Myers proceed so we can make some headway. Go ahead, Mr. Myers.
While you were on the IRB at the University of Wisconsin 10 years ago or so, were you ever issued a warning letter?
I don't remember whether it was a warning letter. I mean, we get inspections and then we get letters pointing out examples of non-compliance. I don't remember if it's titled a warning letter or something else.
So you've gone through FDA inspections where the FDA has found non-compliance in regards to the IRB that you're a member of, true?
I'm not sure if it's true or not. I don't remember if it's non-compliance or if there are issues that they identified that need correction. I don't know if that's specifically called non-compliance.
The FDA, after their inspections, has issued correspondence to you that express some concerns. Can we agree to that?
Yes, sir.
And I can go to the FDA website and literally pull inspection reports, I can pull warning letters, I can pull all kinds of stuff from it. Can I not?
Yes, sir.
And do you know that the FDA literally issues hundreds of warning letters on a yearly basis.
I don't know the number.
Okay? I would like to offer Exhibit 161 into evidence, which is the FDA warning website that lists warning letters for the year 2013.
Was this an exhibit that was, I don't have your list up here, so is this?
It is not an exhibit that has been, but he just told me he didn't know the number of warning labels or warning letters that are issued by the FDA on a yearly basis. And this has that number.
Your Honor, objection wasn't offered, again, at any point in discovery, wasn't offered and is an exhibit. We don't have an authenticating witness here about where this, well, it looks like it came from the USDA, FDA website, but we don't have anybody to authenticate this.
Objection to stay.
Just because someone receives a warning letter, that in and of itself does not mean that there's been an ethical violation, correct?
Correct.
I believe that you spend from page 35 to page 53, roughly 1/3 of your pre-trial testimony talking about advertising issues. Is that accurate?
I don't know, I'd have to go back and read it. If you want me to do that, I'll do it.
You spend, and we agree, you spend a good portion of your time talking about advertising issues in your pre-trial testimony.
Yes,
Mr. Myers, Judge Scotty is asking, could you give us the numbers again, what you were offering as respondents, exhibit what?
161, okay, thank you.
Thank you.
Go ahead.
And this, to me, just seems to be what started the FDA issues for Dr. Burzynski, but there is a letter that is part of volume 1 of the staff's exhibit where and the letter is dated October 18, 2012, and the FDA issued, they had some concerns with Dr. Burzynski's website. Is that a fair summary?
yes, sir.
And you say,
I'm sorry, what page are you on? Okay, thank you.
bear with me. You say that on page 50, yes ma'am, between line 15 and 17, that the FDA prohibits all promotions. Is that your opinion?
Let me read it. Well, it's out of context, so no, that's not my opinion. The way you stated it.
Let me read the answer then, because I don't mean to take it out of context. The prohibition of advertising and promoting unapproved drugs is not just a restriction on inaccurate or misleading promotions, it's a prohibition of all promotions. Did I read that correct?
Yes, but out of context, so it's misleading.
Let me read the next sentence. Even if he had a high level of confidence that these drugs were safe and effective, he's still prohibited from promotional activities if they're not approved by the FDA. Did I read that correctly?
Yes, sir, it's getting closer to the truth.
Because the truth of the matter is that the FDA does not prohibit all promotional activities. True statement?
Correct?
Oh, see.
And even on page 44, line 10, you talk about I have considerable personal experience in my 40 years.
Excuse me, what line are we on?
44, line 10. And in essence, what you're saying, I believe, is that in your role as an IRB member, you have experience in reviewing and evaluating promotional messages, correct?
Yes, sir.
Okay. I didn't understand how to reconcile that with what I read to be that the FDA prohibits all promotional activities, but I think we've now agreed they don't, in fact, prohibit all promotional activities. True?
Correct.
In fact, if we look at what the rule says itself, for the record, Your Honors, this is from the Code of Federal Regulations, Title 21, Section 312.7. What the rule says is you cannot promote that a drug is safe or effective. Agreed? Paraphrasing. I mean, it says what it says.
Right.
I'm just trying to be sure what you're understanding. What you cannot do is promote a drug is safe or effective. True?
That's what it says.
That's what you understand the rule to be.
Correct.
But it is not intended to restrict the full exchange of scientific information concerning the drug, including dissemination of scientific findings in scientific or in lay media. Did I read that correctly?
Continue with the next sentence, yes.
Did I read that correctly was the question?
Yes.
So there is nothing that precludes Dr. Burzynski from publishing the results of his data. In fact, we've seen he's done it at least 74 times, I think more now. There's nothing, the FDA does not prohibit that.
Correct.
Let's see if we can, these are the best copies that I've seen. I want to briefly go through the website with you, okay? And honestly, I don't need to know that I need to read it, but there's the opening page, welcome to the Burzynski Clinic. There's a picture of Dr. Burzynski, a short,
Your Honor, what, excuse me, what exhibit is this?
well, if you've marked it correctly, it's volume 1, staff exhibit 4.
Okay, well, I just needed to know.
Talks about his training, that he has treated thousands of cancer patients from all over the world for 40 years. I'm assuming you don't have any issues with this thing.
No, that's incorrect.
Okay. What are your issues with this thing?
Well, I'm just seeing it now for the first time in a long time, but down in the bottom, it again refers to this personalized medicine approach. And I think that's misleading. And it is, all medicine is personalized in a trivial sense, but the usual understanding of personalized medicine is to do a specific genetic test, create a specific gene therapy, programming T cells, for example, to attack a specific protein in that specific patient. That, as far as I could tell, is not what was going on with most of Dr. Burzynski's patients. So calling this personalized medicine is, I think, creating a false impression that the common use of that word now is what he was doing, and he wasn't.
Page 3 of the website.
We need to take a short break. Mr. Buxton, could you get your exhibits that are archived or out so we can follow along?
Yeah,
For a second,
may I?
why don't we go ahead and take it? If it's all right with you, Mr. Miles,
It
we'll take
is.
a short break.
Absolutely.
I can't read it.
Here you go. Did you get the good copies of the website?
So what this is up here?
Yeah, I don't know.
Mr. Buxton?
Yes, that's in our focus documents. I turned it to
Okay.
the exhibit that is the website. At the bottom of the page, you'll see it identified
Right.
in volume 4.
Okay.
It starts on page 17.
Thank you, Mr. Miles.
And just continuing briefly with the review of the website. The page about Dr. Burzynski and received a PhD in biochemistry, work at Baylor, and here where he's treated some 8,000 patients, assuming that this is not an issue for you.
Incorrect.
Dr. Burzynski is the author and co-author of over 300 scientific publications and presentations in his career. He lists groups. There's a page 21 of the exhibit that talks about the senior oncologists that are there at the clinic, Dr. Yee, Dr. Calderas, and then Dr. Burzynski's son, who is actually, I believe, a family practitioner, if I'm not mistaken. You saw this on the website, did you not?
Yes, sir.
I got a problem. Mr. Buxton, focus document. Don't have all those pages. Is this only part, selections from the website?
It's a selection about, were the subject of our allegations. I didn't pull the pages and put them in here that weren't the subject of our allegations. I restricted myself to in this.
Okay, this is the focus document, but what you were asked to do was to provide the exhibit that shows the website.
Is it over in this stack? It would be volume 1. He gave you the page.
Volume 1,
Yeah,
exhibit 4.
It's in volume 1, or volume 4, page 17.
Volume 1, exhibit 4,
I mean,
pages
exhibit-
17B through 78. Would you mind providing us that? That's what we asked for.
Okay,
You only gave us the parts that you wanted us to see, but we wanted to see the entire website, which is your exhibit.
Understood.
Well, then good. If you understood it, do it.
Yeah, we didn't bring a copy of the entire website. 'Cause,
It's
know,
in your exhibit, isn't it? Volume 7, pages
I mean,
17
hard-
through 78?
A hard copy. We provided the copies on disc because
Okay, I misunderstood. I thought you had the full volumes, and these were just focus documents out of those full volumes. You're saying you don't have the hard copies of the full volume.
that's correct.
I misunderstood.
And you understand that at some point you need to get a hard copy to
I understand.
Okay.
As long as it's identified, they've got it projected on the screen right now. I guess
Well, that
solves the
assumes
problem.
that we can see it. Go ahead.
Judge, I have a copy in our other room. You want it?
That's fine. I just was lost because I couldn't find the pages.
All right. Mr. Myers, just so we can go back and look at the pages when we get back to our
Read it
office.
into the record.
Just to make sure we know exactly which pages.
And Mr. Meyer, I could, let me just ask you, just kind of concentrate on the issues in front of us. We don't need to go through his entire website
No, nor
or
do I.
everybody that's on there.
Nor do I. Fair enough. Can I proceed?
Yes.
page 45, line 1 of your testimony, you acknowledge that there's a statement that says that anti-neoplasms have not been approved for sale or use by the Food and Drug Administration of the United States, etc., or anywhere in the world, correct?
Yes, but out of context.
And and I guess the real issue is this, your implication in your direct testimony. I think you use the term bait and switch. You know what I'm talking about?
Yes, sir.
But if we actually look at Volume 1, Staff Exhibit 4, page 30, what we see here are treatment options. And listed under treatment options are conventional therapies, approved targeted therapies, and experimental therapies. Did I read that correctly?
Yes, but out of context.
And under experimental therapies, it specifically says only patients eligible to enroll into a clinical trial may receive such treatment. Did I read that correctly?
Yes, but out of context.
And then there's a listing on page 31, 32 of Dr. Burzynski's many presentations. And then we get to page 34, Volume 1, Staff Exhibit 4, page 34. And again, anti-neoplasms currently available only within clinical trials. Did I read that correctly?
Yes.
When you finish with it, could you bring it up so we can, I think you've highlighted the relevant part.
I've tried. I can go to page 35. Another page. Anti-neoplasm therapy is an experimental therapy offered at the Burzynski Clinic, currently available only within clinical trials. Did I read that correctly?
Yes.
And then there's actually a whole page entitled Introduction to Clinical Trials. It talks about phase 1 trials, phase 2 trials, phase 3 trials, and the like. You saw that within the website, did you not?
Yes, well, I don't remember which websites I saw, but
Well, you certainly have seen the one in evidence, have you not?
I think so, yes.
And I think up here at the top of this page where it talks about his publications, his many publications, or success stories, patients that have been successfully treated. You saw that on the website, did you not?
Yes, sir.
And then there's actually a link, if not more than one link, I believe, to some of the results of his publications. Actually, some links to some of the publications. You saw that too, correct?
I think so.
And then the Burzynski Research Institute, who is the sponsor of this medication, is a separate website, but something we talked about maybe very early on here today, Doctor. Talked about the Burzynski Research Institute, that it is incorporated in Delaware, that there are 2,027 holders, shareholders. You saw that when you reviewed the Burzynski Research Institute website, did you not?
Probably.
So, let me see if I can summarize to try to move this along. what I believe happened. There was an initial letter from the FDA that is Volume 1, Staff Exhibit 3, page 12 through 17, dated 10/18/2012, in which the FDA expressed some concerns about the website. Fair?
It's part of it.
Well, that's all this was.
I don't have it in front of me, so I don't know if you're characterizing it correctly.
I'm going to get to the other issues. What really began things here, and tell me if this comports with your recollection, is this advertising issue.
I don't know where it began, to be frank.
Well, the earliest document I believe we have from the FDA, although there's 10,000, is 10/18/2012. Now, I won't even represent that to you because I'm not sure that's true. But there was an advertising letter received from the FDA, and then you saw that Dr. Burzynski provided a response. You saw that.
Yes, sir.
And in that response, he tried to justify why he believed the advertisement was proper. And then there was what becomes kind of a pattern here. The FDA says, okay, we accept some of this, but not this. Fair characterization?
It's part of it.
I'm just talking about advertising.
Yes, sir.
I mean, every time a letter was gotten from the FDA, there was a response by Dr. Burzynski, and then a counter from the FDA, and a response by Dr. Burzynski, and a counter by the FDA. Does that comport with your recollection?
Yes, sir.
All right. And this advertising issue was no different. Dr. Burzynski provided a response. The FDA then provided a counter to that response. Dr. Burzynski then provided another response. And ultimately, and this is part of Board's Exhibit Volume 12, page 7031, 6 months after it began, let me show it to you all, from the Department of Health and Human Services. We acknowledge that the Burzynski Institute has discontinued specific content from the website referenced in the untitled letter. In light of action taken by Burzynski Research Institute, they consider this matter closed. Did I read that correctly?
Yes, sir.
So ultimately what happened, there was a letter from the FDA, I think 2 responses by Dr. Burzynski, 2 replies by the FDA, and then they closed the matter, said, you're good. Fair summary?
On the advertising
That's
issue.
what I'm doing. I'm trying to break this down. I'm trying to break 10,000 pages into specific areas. Is that fair?
Yes, sir.
All right. And have you since gone back and looked at Dr. Burzynski's or the Burzynski Clinic's website?
No, not that I recall.
All right. So there, to your knowledge, has been no other advertising issues, no reoccurrences, nothing of that nature. Fair?
I don't have any knowledge one way or the other.
That's fair.
Mr. Myers, can you tell, when was the date of that last letter that indicated they solved the problem?
The date of that letter, Your Honor, was April 17, 2013. In the advertising issue, though, what we looked at was cleared up literally within a matter of months, was it not?
I don't have the dates in front of me.
I believe the establishment was 6 months.
Okay, 6 months. Yet, you spend literally 1/3 of your pretrial testimony addressing the advertising issue. Does that comport with your recollection?
I don't recall the proportion, but I'll accept your characterization.
Now, the FDA closed the advertising issue without issuing any sanctions, disciplinary actions, or warnings. True?
I believe so.
And the FDA has the absolute authority to sanction investigators, does it not?
Absolute, I don't know what that means.
Oh, the FDA has the authority to sanction investigators.
Yes, sir.
I mean, I think that article you have written, you talk about the termination of the investigations both at Duke and at Johns Hopkins. Did you not?
Yes, sir. That was not an FDA action,
In fact, there's statutory authority that's contained in section 312.70 of the Code of Federal Regulations, that if there are repeated failures to comply with FDA requirements, or deliberate failures to comply with FDA requirements, the FDA has a statutorily required mandate that they must initiate a disqualification proceeding, do they not?
I'm not familiar with that specific section of the code.
Do you know and recognize that the FDA has the authority to disqualify an investigator?
I'm not an expert on the details of the FDA's, what sanctions they can apply.
Are you do you know, and I'm not trying to be repetitive, do you know that the FDA has the authority to terminate an IND immediately, a clinical investigation immediately?
I know they have the authority to terminate it. I don't know what immediately means.
We can agree that the FDA has not disqualified Dr. Burzynski, they have not terminated Dr. Burzynski, they have not imposed monetary fines against Dr. Burzynski. True?
To the best of my knowledge.
Is that yes, to the best of your knowledge?
Yes.
What's your answer, yes?
Now, again, trying to compartmentalize, that's what I call advertising. I'm trying to tell you where I'm going, okay? There was an inspection done by the FDA, and what if the inspections are challenging, is that the word you use?
I think so.
There was an inspection at the Burzynski clinic that ran from January 7, 2013 to March 15, 2013. Was that comport with your recollection?
I don't recall dates.
Nor would I expect you to, but does that generally sound right to you?
Sounds plausible.
A 2-month inspection. Is that extraordinary in your experience?
I don't know what the 2 months encompasses, so I can't answer.
When you have been inspected by the FDA in your role as an IRB member, have those inspections taken 2 months?
Well, the amount of time they spend on site is not 2 months, but the total time of the inspection, I assume, takes a lot longer than just the on-site time. So I don't know what you mean by 2 months. I assume that 2 months does not sound like an unusual amount of time to prepare, process, follow up an inspection.
Okay. And as a result of that inspection, the FDA issued what's called a 483 report, which is part of exhibit I believe, Your Honors, it's volume 12, page 7013. You saw the 483 report, correct?
I don't remember the numbers of the reports that I saw.
Do you know what a 483 report is?
Not off the top of my head, no. I may know, but not know it by that number.
Well, it's a term of art, isn't it? FDA inspection reports called 483 reports.
I'll keep the numbers in my head.
Dates of inspection, 1/7/2013 through 15/2013. That's what I talked about, correct?
Yes, sir.
And I want to read this paragraph. This document lists observations made by the FDA representative during their inspection of your facility. They are inspectional observations and do not represent a final agency determination regarding your compliance. Did I read that correctly?
Yes, sir.
Is that what you understand a 483 report to be, or do you just not know?
I don't know.
And the inspectors themselves were three, I guess, two gentlemen, it looks like, and a female. Do you know anything about them or their qualifications?
I don't.
And the observations, I guess they make what's called observations, correct? Is that, there's observation one. I think there's, to be fair, I think there's two different observations, or excuse me, 6 different observations.
Are you asking him about the form? He says he doesn't know. I'm confused as to whether or not this witness has any knowledge of this.
Of this form.
Is this the form, the 483?
The 480, well, I think what the witness, I don't mean to put words in your mouth, I think what he's saying is, I don't know what it is as a 483 form, but he spends portions of his direct pre-file talking about this and the observations.
Oh, thank you.
Does that clarify?
Yes.
Again, Your Honor, I'm objecting to showing Dr. Fost like diagonally part of a document and asking him to testify now instead of saying, okay, here's a copy of the document and take a look at it. It makes it really difficult for Dr. Fost to say anything about any of these documents. We've been quizzed about the numbers, the jargon of the FDA.
In all honesty, I don't want to spend a great deal of time on it. I want to expedite the process here.
Go ahead and proceed. And Dr. Faust, if you need to see the exhibit as to see it, it's in evidence, as I understand, is that correct?
It's in evidence, yes.
Proceed.
There are 6 different observations that were made by the investigators. God, let me go to 6. I'm not trying to trick you, I promise you.
If you have a hard copy of the exhibit that doesn't have any attorney information on it, can you let them know?
I don't have it readily available. I have it somewhere. There's observation 6. Okay?
Okay.
And what that, and I don't know what you've seen and what you haven't seen, is my problem. But after this inspection, and they came up with 6 observations, there was a response by Dr. Burzynski. Have you seen that?
I believe so.
Are we still on advertising or?
We're not on advertising. We are talking about an inspection
Thank you.
that occurred, what I believe to be as a result of the advertising, but an inspection, a 2-month inspection.
The April 7th, 2013 to March 15th, 2013.
Yes, ma'am.
All right, thank you.
And I guess,
I'm sorry, January 7th, I said April, and I might have.
but let me see if I can answer this. Because I really don't want to go through all the pages, and I know they don't want to either. But here's what I perceive. There was an inspection, correct?
Yes, sir.
There was then what I call, what is known by the FDA, a 483 report with 6 observations against the claim. Fair?
Yes, sir.
Dr. Burzynski then responded to the 483 report, and this is part of Exhibit 12, starts on page 7165. It's part of the cover letter. We recognize and take seriously the observations in the FDA 483 and are committed to taking all actions necessary to address them as part of our effort to continually strengthen our process. You saw that letter when you reviewed things, did you not?
I believe so.
And then his response itself is (294 pages), complete with cross-references to medical literature, to patient records, and the like. Did you see that in the chart?
I believe so.
And thereafter, the FDA acknowledged his response and then issued what's called a warning letter. Does that comport with your recollection?
Yes, sir.
That warning letter, let me get my dates right. Was issued on December 3, 2013. And in essence, this is the same process as I perceive it as the advertising issue. There was something from the FDA, a response from Dr. Burzynski, a reply to that response, another response, another reply. Did you glean that from reviewing the records?
Yes, sir.
It's a continual process that goes on. God, I think this went on for close to 2 years, did it not?
Yes, sir.
And in the warning letter, the FDA, the letter speaks for itself, but it then asked for Dr. Burzynski to submit a response to the warning letter. That's the way this works. FDA sends something, Dr. Burzynski responds, FDA sends something else, asking for a further response. It goes back and forth. Fair?
Yes, sir.
Here is Dr. Burzynski's response to the warning letter. And it is staff exhibit the entire volume of number 15. Do you know how many pages are here?
No, sir.
1,222. That's his response to the warning letter. Now, you then did glean from the records that, just like the advertising issue, there was a response, a reply, a response, a reply, a response, and ultimately, things are closed. You glean that, true?
Yes, sir.
All right. Things are closed in regards to the clinical investigation without sanctions, without discipline. True?
At one point, there was a clinical hold. I don't keep the dates in my mind.
The clinical hold was imposed on the sponsor, was it not?
I don't remember the details.
Let's go there.
Sounds plausible.
Let's go there.
Okay, before you go there, let me understand the timeline. So we started this inspection in January of 2013. You have a warning letter issued in December 2013?
Yes, the warning letter was December 3, 2013.
Okay. And so
The response, which I held up, which
that big response to the warning letter.
was December 23, 2013. And thereafter, there were multiple response. I don't have the dates of that because I didn't want to get too tedious.
But you said it was resolved.
And I don't know the date that it was ultimately resolved. Now, to be fair, and you brought up, there was a clinical hold put on the sponsor of this investigation, true?
Sounds correct.
Let's go there. But as far as investigator, clinical investigator, this man, the FDA did not impose sanctions against him. Agreed?
I think it's a mischaracterization.
Did the FDA impose sanctions against the investigator?
I consider a clinical hold a sanction that affects the investigator.
Okay. Even though the clinical hold is directed to the sponsor?
That seems to me a technical, legal aspect of it, but the bottom line is to prevent the investigator from using the drug in the way he was.
Well, that's not true. Do you
Your
know what
Honor,
the...
I'm going to object if he's characterizing testimony of the witness as not being true.
Well, just make it a question, please.
I will, I'm sorry. The witness is mischaracterizing. I'll be quiet. The clinical hold issue involved what's called the investigator brochure. I'm showing you volume 12, beginning 6960. They had concerns about the investigator's brochure. Did you glean that from the records?
Yes, sir.
The investigator's brochure, as I understand it, first of all, is the duty and responsibility of the sponsor. True?
As I say, I think it's inseparable from the effect on the investigator. But technically true, yes.
Just so we have a clear record. The investigator's brochure is the responsibility of the sponsor. True?
Multiple responsibilities, but partially the sponsor, yes.
Well, it's the duty and responsibility of the sponsor to submit the investigator's brochure to the FDA.
Correct.
Is that right?
Yes, sir.
We agree on that?
Yes, sir.
And the reason that the sponsor in this case was put on a clinical hold for a period of time was due to the investigator brochure. We agree? We on the same page?
Yes, sir.
All right.
You're saying investigate towards the threshold?
Yes, ma'am. And let me see. The investigator brochure, as I understand it, is a summary of the clinical trial. That a good layman's term?
Yes, sir.
All right. And the FDA initiated a clinical hold because they had some concerns with the FDA brochure, and they asked the sponsor to rewrite the brochure. Did they not?
I don't remember the details.
All right. On April 9 of 2013, which is volume 10, of board exhibit, there is a letter from the sponsor dated April 9, 2013, I said that, with the rewritten brochure? Did you see that in the records?
I don't recall.
Do you know how many pages this is?
No, sir.
468, I believe. The FDA, as they have done with prior issues, then said, okay, and I'm summarizing, paraphrasing, so correct me if I'm wrong. We accept portions of what you've done, but you still have further to go. You still need to do this. So they rewrite the brochure, the FDA then says, okay, you've gotten better, but you still got to do this. Fair characterization?
I don't recall the details, and I don't have the correspondence in front of me.
Right. Do you know how many times the sponsor rewrote the investigator's brochure in response to this back and forth, back and forth, back and forth?
No, sir.
Would it surprise you that it took 8 rewrites before the FDA said, okay, now you're good?
No, sir.
And in fact, I think the 7th time they were arguing about 2 words in a sentence. Is this part of the meticulous attention to detail that you wrote about in your article?
I doubt it, but I need to see the document to be sure.
Well, let me show you. Because finally, the clinical hold, in a letter from the FDA, they finally said, okay, yay, we got it right. June 20, 2014,
I'm going to object to testimony about what, yay, we got it right. If he's asking the witness
Mr. Stein, you need to
to
ask a question.
I wasn't. I paused because my copy is a color copy that doesn't have the exhibit number, and I.
Just go ahead and ask your question, but leave objections instead.
And first of all, it was a partial clinical hold, correct?
Yes, sir.
All right, it wasn't a complete shutdown of the investigation. Correct?
I don't know the details.
Directed to the sponsor, the Burzynski research, and there's been a removal of the partial clinical hold, and just for date purposes, signed by Patricia Keegan on June 20, 2014. Did you see this in the records?
I don't recall details. I've looked at tens of thousands of pages. I don't recall which documents I saw.
So to summarize, the sponsor, not the investigator, was put on partial clinical hold on January 9, 2013 because of an investigator brochure. There were 8 rewrites to the brochure, and literally a year and a half later almost, in June 20, 2014, the partial hold is lifted. Fair summary?
I don't recall.
Your Honor, again, this is not showing, I know it takes longer, but not showing the.
Well, one of the problems, Mr. Buckstein, is we don't have the hard copies of the exhibits that have been omitted. Therefore, it's impossible to show it to the witness. I recommend that you spend some time tonight and get them reduced to hard copies so that the witness needs to look at it. Okay.
Thank you.
Go ahead. and
Thank
proceed,
you.
Mr. Buckstein.
Thank you, Your Honor. I guess the point I'm trying to make here, Doctor, with it in all honesty, is that every time the FDA asked Dr. Burzynski to do something, he responded. Fair?
Yes, sir.
Every time the FDA
Well,
asked...
it's correction, sir. Not to do something. I don't know if he responded by doing what he was supposed to do, but he did respond to the FDA letters.
Well, and we saw in the cover letter that he was committed to taking corrective action and getting it right. We read that. Correct?
Yes, sir.
And every time the FDA asked Dr. Burzynski as a clinical investigator to jump through this hoop or that hoop, he attempted to do so. Fair?
I don't know if that's true or not.
I mean, it just seems remarkable to me that you have to rewrite a brochure 8 times, that you have to submit a 1,222.
Mr. Myers asked the witness a question.
Why would
You
anyone
may
do-
not agree with it.
Why would anyone do this? Why would anyone subject themselves to this?
To avoid sanctions by the FDA would be one good reason.
You know what another good reason might be? Maybe it's because he believes in what he's doing. Maybe he believes that he wants to help patients. Maybe he wants
All
to
right,
save
that's
lives.
fine, Mr. Myers.
Do you agree?
You know that's not a question, and it's argument.
All right. I had asked you earlier about the way the clinic is set up. And I think you said I had seen this. This is our exhibit. It's our exhibit 2, Your Honor. Dr. Burzynski is.
I'm sorry. Hang on. All right,
It's 3, I'm sorry.
Judge Scotty was pointing out that at this point, they haven't been admitted into evidence, but I'll remind you, same with your question.
It is free.
It's respondents free. And Dr. Pass, I understand you had seen this document before.
Yes, ma'am.
All right, go ahead.
Dr. Burzynski, just an impertinent part. Dr. Burzynski is the owner of the Burzynski Clinic. And then down here we have board certified oncologists, and under them work internists or family practitioners, and then under them work what are called research associates. Some of these who are actually physicians in other countries. Do you understand how the entity is set up?
I think so, yes.
And then on this is kind of the clinical side. And then over here you have more what I call an administrative side, which includes billing and finance. Correct? Is that what your understanding is?
Yes, sir.
And do you also understand that when patients come in the door at the Burzynski Clinic, cancer patients, mostly or sick patients, that they are assigned a board-certified oncologist they are assigned a board-certified oncologist. You understand that?
I didn't pay particular attention to the way in which patients are assigned.
You did glean from the records, though, that the patients had board-certified oncologists who managed the day-to-day treatment of the patients. Fair?
Yes, sir.
The board-certified oncologist, or, well, I'll even expand that. The board-certified oncologists, or the internists and family practitioners who work under them, were the ones that were actually performing the physical examinations. True?
I didn't pay a lot of attention to who was doing exactly what. I know that some people were doing exams and others were doing other things, but I didn't consider that my primary area that I was going to be called to give expert testimony about.
Well, you expressed some of the opinions questioning delegations to certain doctors, and did you not in your pretrial testimony?
Yes, sir.
Yet you didn't pay attention to how patients, sick cancer patients are assigned and who does what and who operates under who. You didn't pay attention to that?
Some parts of it I did. There were some levels of detail that seemed to me less important.
And then there is an issue that I believe you bring up on page 60 of your pretrial testimony. And it has to do with this gentleman right here, the radiology tech, a Mr. or Dr. Khan. I think the evidence is that Dr. Khan is a physician in another country. Do you know, under the Texas Medical Board rules and regulations, or the Texas Medical Practice Act, what the duties and responsibilities of a radiology tech are?
No, sir.
Do you know, under Texas law and the applicable board rules and regulations, whether a radiology tech can in fact take simple measurements on films?
No, sir.
Patient J. I told you we'd get there. We're there.
Before we get to patient J, I have a question about this. I'm reading your testimony here on Fost, and I'm trying to understand. You're saying here that the measuring of tumors on radiological images is practice of medicine? Is that what you're saying?
Which line are we referring to?
We're reading lines 25 through 33 on page 60. 60, yes.
You're asking me whether I think that...
Oh, and I'm asking if this is, am I reading this right, that you're saying that Dr. Khan, Mr. Khan, whatever, measuring of tumors on radiological imaging, like MRIs, PETs, and CT scans, is the practice of medicine?
If it affects decision-making about patients, yes.
And along those lines, my understanding from the next page, was your concern that he did not sign, that he is the one who did the measurements? That Dr. Collins did not sign off as doing the measurements?
Which line are we on, Your Honor?
The beginning of line 1 on page 61.
61, Your Honor?
I'm just trying to understand what your allegation is about Dr. Collins.
I think the concern was that Dr. Khan, one concern, was that he was doing measurements but not taking personal responsibility for it by signing off on it.
So it's a lack of his signature or indication on the report that he performed the measurements?
And takes responsibility, that's one concern, yes.
Okay, well, I guess I'm confused then. I mean, if he's a radiological technician, is he practicing medicine when he measures tumors?
If it's affecting clinical decisions, I would think so.
Well, where do you say he's affecting clinical decisions here? You said that it's the practice of medicine.
Because it's my impression that it was affecting clinical decisions.
maybe Mr. Buxton can help me out on.
May I proceed, Joe?
You may.
So what you're saying is if it doesn't affect the decision-making in regards to the patient, that is not the practice of medicine, true?
That would be one thing that would not make it true, yes. I mean, if you were doing it, for example, just as part of for research study to get information about research, and it did not involve the care of the patient, then it arguably would not involve the practice of medicine.
Well, I thought you answered Judge Skaday's question that if the measurement of tumors affects the decision-making of the patient, then that would be the practice of medicine. Did I misunderstand you?
No, sir.
So conversely, if it does not affect the decision-making of the patient, then it would not be the practice of medicine.
Apparently not.
Patient J, may I go to patient J now?
Yeah, that's fine.
Okay. I think it starts on 62. I think this is the last issue. So. Patient J was a patient, by reviewing the records, that had a very, very serious brain cancer. Does that comport with your recollection?
I don't recall.
Patient J was admitted under FDA procedures and protocols, which are called a single patient protocol. Does that comport with your recollection?
Yes, sir.
Also, or it used to be called a compassionate use protocol. Are you familiar with that?
I'm familiar with that, and it's a misuse of the term. In this case, would be a misuse of the term in this case.
Objection, Your Honor, is non-responsive.
He's answered.
The single patient protocols is codified in 21 CFR 312.305 for the judge's reference. 312.305. But for the single patient protocols to be applicable, the patient must have a serious or immediately life-threatening disease or condition. Correct?
Say that again?
For the patient to be eligible for what's called a single patient protocol, they must have a serious or immediately life-threatening disease or condition. True?
Yes, sir.
For a patient to receive single patient protocol, in essence, they have to be in extremely poor shape where treatment is potentially of the essence. Agreed?
Yes, sir.
Time is of the essence, I think is what I meant to say. True?
Yes and no.
Well, the quicker you get to treat somebody, the better chance you're going to have a good response. Fair? As a general concept.
Not always true, no, sir. And sometimes you have an emergency where it's important to start treatment in the next hour. Sometimes it's important to start it within a matter of days. Sometimes weeks matter. Those are not the same. So whether or not you have an emergency depends on which of those parameters you're talking about.
Are you really taking issue with my statement that the sooner you start treating cancer, the better the prognosis is? You don't take issue with that, do you?
Yes, sir, I do.
You base that upon your 0 patients of cancer that you treat?
No, I base it on review of the literature and longstanding involvement with cancer, cancer therapy, cancer literature, cancer research.
And the issue with patient J, quite frankly, was there was an issue with the operation of the IRB, correct? That was issue one.
Yes, sir.
And the issue was that the IRB provided what's called a provisional approval to the patient so that this seriously sick child could receive treatment. And the FDA came back and said, IRB, you can't do that. Fair summary?
That's a it's a partial explanation, yes.
Are you familiar with the term form over substance?
Yes, sir.
I've got too much paper on my desk, Your Honor. The second issue was with patient K. Involved, J, sorry, it's late. Involved the reporting of adverse events by the sponsor. Fair?
Yes, sir.
Now, tell me if I understand what the law is in reporting of adverse events. First of all, the investigator must report adverse events to the sponsor which are possibly related to the drug administration. Fair?
Yes, sir.
So there has to be a causal connection or a possible causal connection between drug administration and adverse event. Fair?
Yes, sir.
So things that were pre-existing drug administration or pre-existing conditions do not necessarily have to be reported. True?
Correct.
Adverse events that are unrelated to drug administration do not have to be reported. True?
Well, serious adverse events have to be reported.
Okay.
Deaths, for example, have to be reported.
That's true, and I appreciate that. But adverse events that are not serious, that are unrelated to drug administration, do not have to be reported. Fair?
No, sir.
Well, let's look at the statute. Do you know where the statute is that defines the terms adverse events and what must and must not be, or doesn't necessarily have to be reported?
I could save you some time if I could give an expanded answer, but if you want to do it yes and no, we'll go that way. No, I don't know where the statute is.
312.32? 21 CFR 312.32.
You're talking about the regulations.
Yes, ma'am. And this is talking about what the responsibility of the sponsor is to report adverse events to the FDA. And here it says serious and unexpected suspected adverse reaction. Tell me if I've read this correctly.
Yes.
The sponsor must report any suspected adverse reaction that is both serious and unexpected. Did I read that correctly?
Yes, sir.
Serious and unexpected. And the next sentence, the sponsor must report an adverse event as a suspected adverse event only if there is evidence to suggest a causal relationship between the drug and the adverse event, blah, blah, blah. Did I read that correctly?
Yes, sir.
So the responsibility for reporting to the FDA is that of the sponsor, correct?
Yes, sir.
You're getting repetitive.
I'm just trying to sum it all up. Yes, ma'am. Last section that you address on patient J involves tumor measurements. And I think, let me see if I can summarize what I understand your opinion to be. That is, that there were tumor measurements within the medical records that showed that this patient's tumors were initially decreasing and then increasing some, and you took issue with the fact that this was classified as stable disease. Fair?
Yes, sir.
And I'm going to refer to volume 61 of the board's exhibits. I promise you I'll put it up on the screen. 42128.
This is image.
Can y'all read that?
Okay, now. All right.
And you see that the baseline lesion, the tumor burden, as I understand is a term of art where you measure width times length, is 21.6, correct?
Yes, sir.
We go down here a month into treatment on July 6, 2012, and it has, the tumor burden has decreased to 16.8, a decrease of 22.2%, correct?
Correct.
And then we go to the final date, August 24, 2012, and the tumor had actually increased some from the prior reading, but decreased compared to the first reading, and the total tumor measurement is 19.8, correct?
No, sir.
I read that wrong.
Well, you said it increased some. It increased by a substantial amount. It increased 18%. I wouldn't call that some. I'd call that a substantial increase.
Fantastic. What does the protocol say has to be reported? What is the, how does the protocol define the term standard stable disease?
I don't recall.
If you're going to offer an opinion that this is a wrong classification, should you know what the protocol says constitutes stable disease?
Probably did at the time I wrote it. I don't have it in front of me.
If the protocol, and I wish I had a hard copy of it, if the protocol established stable disease as an increase of less than 25%, then this would be correctly classified as a stable disease, would it not?
I need to see the protocol.
I'm asking you to assume if the protocols define, the protocols that were approved by the FDA, that were put forward by the sponsor, if they define stable disease as a tumor that increases by less than 25%, assume that to be true. I have a hard copy of it. If that's correct, then would you agree that this has been correctly classified as stable disease?
Yes, sir.
I'm gonna pass the witness.
Great.
5-minute break.
Thank you. Thank you, and thank you, Dr. Fost, for being so patient. When were you last a member of NIRB?
It was 5 to 10 years ago. I don't know the exact date.
Okay, but when did you last consult some entity in your consultation functions about IRB-related issues?
Within the last month or two. I mean, I do that on a regular basis.
So, did you stop being abreast of what is required expected of IRBs because you stopped being a member?
No, I'm fully engaged in IRB-related matters.
There was a question about your publications about cancer. You're not an oncologist, right? You testified about that.
Correct.
So you've never held that opinion, you've never offered that opinion, correct?
Correct.
Okay. But what opinions have you had that relate to clinical trials for cancer medications?
I've been, the Vietnam paper with Dr. Love was one of the most complicated, controversial cancer trials ever done. The article we wrote won an award, but that's involved years of becoming very familiar with the various approaches to treating breast cancer. The articles that I was involved with involving the prostate cancer prevention trial involved 10 years of serving on a data monitoring committee on one of the largest clinical trials ever done on prostate cancer. So those are examples of involvement with clinical trials of cancer, which required knowing fully all the medical facts as well as the ethical and regulatory issues.
What experience do you have reviewing medical records? And particularly medical records of cancer treatment?
Reviewing medical records of cancer treatment, I don't do that. That's not a major part of my work.
When you were reviewing the records that were sent to you by the board, were the actual medical records for the patients sent to you?
Yes, sir.
Okay. So, like for instance, patients A through F, did you review those medical records in order to give an opinion as an expert on the care and treatment of cancer?
Yes, sir.
Okay. Did you hear me what I said? I asked you if you reviewed those records to give an expert opinion about the care and treatment of cancer.
About the care and treatment of cancer, it was mostly about the investigational studies on those patients, the consent process, and there was such a blurred boundary between care and treatment on the one hand and research on the other that they spilled over into each other.
But did the board ask you to give an opinion about whether or not the standard of care was met for cancer treatment for those patients?
Not with regard to cancer treatment.
Okay. What are the NCCN guidelines regarding cancer treatment?
That's an agency that tries to issue consensus guidelines on what the preferred or recommended treatments are for various cancers.
Mr. Buxton, could you give me the acronym again?
N,
I'm getting congested.
N as in Nancy, C as in cat, C as in cat, N as in Nancy, NCCN.
Thank you.
And how would you know and be familiar with the guidelines if you're not an oncologist?
Because in my multiple other roles, both as an IRB chair, where I've seen thousands of research protocols, that part of the background information for those protocols involve existing guidelines. My capacity as a member of the NIH Recombinant Advisory Committee, same thing, applications of complex treatments of cancer. The background materials necessarily include the existing guidelines for standard treatment of cancers. And in my experience with the Wisconsin IRB, that kind of information would routinely be present in the submitted materials.
Did you need to be actually ordering, prescribing these drugs for patients in order to become familiar with the NCCN guidelines?
No, sir.
You did say that you never served in the role of principal investigator in a cancer trial.
Yes, correct.
Okay. But what about your role in being on the IRBs that you've been on that are related to cancer trials? How would you be familiar with the role of a principal investigator in those cancer trials?
Every single trial, every single grant that I've reviewed, every study section that I'm on, every data monitoring committee that I'm on, we're always dealing directly with the principal investigator, not only his or her correspondence, but materials, talking to them, dealing with them about problems that they arise. So I've spent 40 years dealing with principal investigators at many different levels.
Okay. Do you have an opinion about whether it would be fair to characterize what you're doing as policing the clinical investigator in the trial?
Overruled.
I don't like the word policing. I would call it, it's a regulatory oversight function. Policing is an ugly word in this community.
Okay. Would you just briefly explain phase 1, phase 2, and phase 3 studies, clinical studies, the relationship between those three?
Phase 1 is a new chemical entity. When we're talking with drugs, it's never been used in humans, mainly to learn about toxicity, gross toxicity, and looking for a safe dose. If that leads to a phase 2, which is to give it to a relatively small number of patients to see if there's any sign of effectiveness, any evidence that some patients got better. The purpose of that is to see if there's enough encouragement about possible effectiveness to do the phase 3 trial, and that's the definitive trial, or what's called the pivotal trial. That's the one in which you find out whether it's really effective by doing a prospective randomized controlled trial in which you compare the new agent against either an existing agent, or if there are no existing agents, against placebo. But it's the phase 3 trial that counts for reaching conclusions about whether the drug is safe and effective.
Okay. What validity would there be to comparing the results of one phase 2 trial with another phase 2 trial?
Almost none. I mean, you have different groups of patients at different centers getting different ancillary treatments. You don't have the standardization of diagnosis and management across 2 different studies, even within one center. So comparing a phase 2 to another phase 2 is of very little value.
Okay. What about comparing the results of a phase 2 study with the results of phase 3 studies?
Again, almost no comparison. That's why the FDA requires phase 3 trials to approve a drug, because it's only when you do a head-to-head comparison of the new intervention against some existing intervention, or placebo if there's none, that you can get reliable evidence for safety and efficacy. That's been the standard now for 70 years.
And I asked you what validity would it have? What validity would it have to make that comparison?
I think he said none.
Oh,
Is that what you said?
The validity of a phase 2 trial?
we're comparing it to the results of the phase 3 trial.
Little to none.
You in development, R&D, to get a drug to where it's approved and can be sold, marketed. Is that an excuse for failing to meet the discipline of science?
No, sir.
You talked about agents that were once standard of care, that it's changed, and now something else has become the standard of care. You remember that testimony?
Yes, sir.
And thinking about the NCCN guidelines, what happens in the NCC guidelines when there's that kind of change in the standard, the recognized standard of care?
They changed their recommendations.
Okay. On what you were asked about the frequency. I mean, is it like every 10 years or something like that they change the NCCN guidelines?
I don't really know.
In a situation where you have a sponsor, a typical sponsor that you've dealt with, what treatment do they generally, I believe you testified to this, what treatment do they give the patient themselves, the sponsor?
Sponsors are not involved in treatment.
Okay, investigators, in typical situation you've always dealt with, what do they do as far as treatment of the patient?
There's two big categories. There's sometimes investigators have no involvement with the treatment. They just design and administer the trial. In other cases, clinicians play both, sometimes play both roles as an investigator and clinician.
Okay. Do you recall documents in this case, multiple documents in this case, saying Dr. B recommends something or Dr. B's recommendations?
Yes, sir.
Okay, what does that indicate to you as to what Dr. Burzynski's role was and what you just said about characterizing a clinical investigator who treats patient or doesn't treat the patient?
My impression was that he was generally playing both roles, in fact, all three roles. That is, as treating clinician, as investigator, and as head of the sponsoring agency, the Institute.
And what conflicts do you see in placing yourself in all three roles?
The worst of all possible conflicts, and unique is the word I used. I've never heard or seen anything like it. It's unknown in my experience for the sponsor of a trial, or the person who's head of the agency that is the sponsor, to be so directly involved in the conduct of the trial and in the clinical day-to-day care of the patients. So there almost always in the institutions that I'm familiar with, management plans required to try to reduce this conflict of interest so that decisions about patient care are not unduly affected by the interest of the sponsor, let's say, in making money.
In reviewing the documents for this case that you looked at, did you see any indication that there's anything even approaching that kind of conflict of interest management plan?
I don't remember anything about it, which is unusual.
Okay. You've been involved in clinical investigations on IRB that weren't investigating a cancer drug, correct?
Yes, sir.
And you've been involved in ones that were investigating cancer drugs.
Yes, sir.
What difference in the ethical duties of the clinical investigators was there between the studies and investigations that are for cancer drugs and the ones that are for non-cancer drugs?
No difference. The duties are the same no matter what is being studied or what the disease is.
Okay, you did testify about the FDA doesn't, the law that you're aware of, doesn't prohibit Dr. Burzynski from publishing the results of his studies, correct?
If by publishing you mean publishing in scientific journals, yes, sir.
Right. What about, how would that be different at all if he is publishing the results of these studies on his website?
Well, that's generally considered promotional activity. It's certainly what the FDA considered promotional activity, and it's prohibited for drugs that are not approved, which in the case of antineoplastons, they were not approved, and therefore that's why they were concerned about it.
What is your opinion as to whether statements about safety and efficacy, promotional statements about safety and efficacy are prohibited by the FDA?
For unapproved drugs, all promotional activities are prohibited, or at least prohibited, and both about safety and efficacy.
Is there, what is your opinion about the significance of a prohibition of statements about safety and efficacy versus other kinds of promotional statements?
Well, it's at the heart of the matter, and that is a patient, particularly a patient who's desperately ill, terminally ill, with otherwise untreatable cancer, is very susceptible and vulnerable to claims of miracle cures. And when they read on a website that there's something that is safe and effective, or both, they will understandably be drawn to go to wherever they can get that, sometimes no matter what the cost. So misleading statements about safety and efficacy prey on these very vulnerable groups of patients and their parents.
What is your opinion as to whether the number of pages in a protocol tell you anything about whether it's adequately detailed?
None. Little or nothing. The longest ones are often the ones that are the least helpful.
If you reviewed the warning letters from the FDA to Dr. Burzynski as sponsor, or as someone who was representing the sponsor, BRI Incorporated, you remember those?
Yeah, as I said, I don't remember whether they were characterized as warnings, but I saw the correspondence that you sent me between the FDA and the Institute and Dr. Burzynski.
Okay. And some of those letters also were, did you review the letters that were to Dr. Burzynski as the investigator?
Yes.
Okay. And did your, what did your review of those records, in this case, confirm about whether those warning letters were detailing, or accurately detailing ethical violations?
You're talking about just the promotion, the letters about the promotional activities?
Well, the first the letters about the promotional activities.
Well, they clearly detailed promotional activities that were improper under the FDA rules.
So when you looked at the materials that the FDA had pointed out, did what confirmation did you get that indeed there had been ethical violations?
It provided substantial support for the concern that there were serious ethical and regulatory violations.
Okay. Now switching to those, the warning letters about the 2013, the results of the 2013 inspection. What did your review of the records confirm, if anything, about whether what was in those warning letters were accurate details about ethical violations of Dr. Burzynski?
As I said, I don't keep in my head which letters were on which date, so I'm not 100% sure that what I'm about to say was the 2013 letter or what year they were in. But there was certainly correspondence between the FDA and Dr. Burzynski and or the Burzynski Institute of numerous serious violations of the conduct of clinical trials at the Burzynski Institute/Clinic and of the conduct of the IRB.
And so specifically zeroing in, you gave an opinion specifically about patient J.
Yes, sir.
All right. So what did your review of patient J's records related to the particular topics that you gave an opinion about in your pre-file testimony about the imaging measurements and the adverse event reporting, what did those records, if anything, confirm about whether there had been ethical violations by Dr. Burzynski?
Well, they were in several areas. I would start with the consent process, and I would emphasize that the consent process is just that, a process, not an event. So a consent form is not the sum and substance of the consent process.
Your Honor, he never said anything about consent on patient J, so he's going not only outside of pre-call testimony, he wasn't asking a single question about consent for patient J, so he is going outside of my cross.
Yeah, he did. You did go outside the cross-examination. I just trying to get you to focus on what you talked about in the cross-examination, which I believe was evaluating the tumor response, measuring radiological images, and adverse event reporting.
And the conduct of the role of the IRB in overseeing it.
Yeah.
So let me start with that. The IRB was not appropriately constituted. It may have had legally adequate membership, but it was often chaired by an individual who was not an MD, by a person who's with an MBA, a layperson, who by himself, I don't remember if this was specifically patient J, so I'm sorry I don't keep each of these in my mind, but there were recurrent episodes of this single individual authorizing.
Dr. Bass, you were asked only about patient J, so you
Yeah,
need to make sure that what you're testifying to pertains to patient J.
Well, one thing I'm certain about, does apply to patient J, is that there was a, quote, emergency, end quote. I don't think it was a true emergency, but there was an urgent approval by a single individual at the IRB with the understanding, as required by the FDA, that that single individual's approval be ratified by the entire IRB. And that didn't happen for quite a long time afterwards.
Okay, and did that happen after treatment began?
It happened well after treatment began.
Okay, so what is the problem with having this provisional approval by a person who doesn't have a medical background before the full IRB meetings?
Because part of one of the many lines of assurance to these patients that their care is being properly, that there's proper oversight of their care, and they're reassured that an IRB is overseeing this research. And in this case, that would imply that they're doing it in the way they're supposed to be doing it. Just to say that some guy who happens to be on the IRB signs off on it is not appropriate IRB oversight. So it's a false reassurance to the patient that some independent committee is overseeing what's going on.
So I'm changing this up. What does a fact, assume this fact, that a patient's cancer is likely to be fatal fairly soon, within a few months, what does that have to do with whether or not they get the standard of care treatment that the NCCN guidelines list for that particular cancer at that particular stage?
Objection is not qualified to render that opinion. You're not an expert on cancer.
I want to rephrase the question, Mr. Foster.
Okay. Well, I'm going to rephrase it. Well, what does the fact that assumes the fact that a patient has a normally soon to be fatal cancer have to do with their ethical responsibility, the physician's ethical responsibility?
Responsibilities are the same to all patients, no matter how ill they are.
Well, what change is there to this responsibility if the patient is suffering from what is usually called a terminal disease?
Well, if anything, the responsibility is higher. The patient is desperate, vulnerable, susceptible to promises of something that they think might help them.
Okay, I'm going to go back to, remember, the discipline of science, phase 1 through phase 3. Remember that?
Mm-hmm.
Okay, how does the development of targeted therapy, I know you gave like 3 definitions for the word targeted there, but how does the development of targeted therapy change the discipline of science?
It's one of the great advances in oncology, and it's just at the front end now, so we don't yet know how widely applicable it would be, but there have been dramatic cures of patients with malignancies that were previously thought to be untreatable. But by targeted therapy, I'm referring to therapies that I did not see any evidence of at the Burzynski clinic, in the records that I saw.
Do you teach the medical history?
Yes, sir.
Okay. And in your knowledge of medical history, did the development of these targeted therapies come from somewhere outside of the discipline of science?
No, sir.
Okay, we looked at the website, remember?
Yes, sir.
Okay.
You're
And
talking about Brzezinski's website.
Dr. Burzynski's website,
Yes,
remember that? Starting at volume 4, page 17. Okay. And there were a lot of, Mr. Myers pointed out, there's a lot of places where it says you have to be in a clinical trial to get an neoplasm.
Yes, sir.
Remember that? Okay. What, if any, expectation does that kind of message in the website create for patients when they look at that about whether they are going to get into this kind of clinical trial at the Burzynski clinic?
Objection, speculation.
I'm sorry, my voice is going. Sustained.
What familiarity do you have with the expectations created by marketing materials, the consumer expectations that are created by marketing materials for drugs?
It's the whole purpose of marketing materials, is to get consumers to seek the product. And with the expectation that obviously that they'll be benefited.
So what is your expertise? Do you have any expertise about that area?
Objection, outside the scope of cross.
Sustained.
Your Honor, he talked over and over about what the clinic says you can only get here if you in the neoplastons and you
Did
get
not
the
talk
clinical.
about expectations, there was nothing about that.
It's been a long day.
Thinking about or considering the situation of Dr. Burzynski in a dual role involved with the sponsor and the investigator, if any, what conflicts of interest does that create about reporting adverse events honestly?
Well, when the investigator and the sponsor and the clinician are the same, there's the concern that the opportunity to make a lot of money if the product is successful and can be approved by the FDA and marketed. There's a tremendous incentive to distort information, to conduct trials in a way that will obscure serious adverse events or overstate efficacy, to write publications in a way that are misleading. We've seen this over and over again in the history of medicine. So that's why we just recently in our history, we have such strict rules about conflicts of interest and requirements that conflicts of interest be managed so that one individual doesn't play all of those roles at the same time.
Okay. Assuming, what Mr. Myers had told you, BRI Incorporated is a corporation, Delaware corporation. What effect does that have on Dr. Burzynski's ethical responsibility in his role with BRI Incorporated, the sponsor that you saw evidence in the records that you looked at?
Your question is, as head of, in his capacity as head of BRI, what are his ethical responsibilities?
Yes.
Well, he has a duty to make sure that it conducts its business, that is the clinical trials, for example, that it sponsors, in an ethically and legally appropriate way.
Okay, so now would you focus in and tell us what the ethical responsibilities are of Dr. B in that role, that are his ethical responsibilities as a physician?
Well, they're much the
Hold on,
same.
objection. Vague and ambiguous. What role?
We haven't established, I
I don't
haven't heard
understand.
anywhere, anybody established what his role is at BRI.
Okay, great question. What do you understand Dr. Burzynski's role to be at BRI Incorporated?
My understanding is that he's the head of it. I don't remember whether the title is president or CEO, but my impression is that he's the top person.
Okay. If there is evidence that he is like the 80% owner or more of BRI Incorporated, what does that indicate to you his role is?
He has a major responsibility to make sure it's conducting its business, or in this case, its clinical trials, in a responsible way.
Okay. So now he's who you identified, the person who's in charge of BRI Incorporated. Is that what you said?
Yes, sir.
Okay. And he's a physician at the same time. What are his ethical responsibilities as a physician in that situation?
I'd say to get out of one of those roles. That is, to do one or the other, but not both. As I said, I've just never heard of that ever, and it would not be allowed at my university or any place that I'm familiar with.
Why?
Because of the conflict of interest and the numerous historical examples of that investigators that have these conflicts, even though they may be compassionate and caring physicians, when they get into this conflict where they're trying to act as investigators and, in this case, as a sponsor, which I've never heard of, that historically these conflicts of interest lead to behaviors that are to the serious detriment of the patients that they're taking care of. That is the interest in developing new knowledge or in developing a product that can be remunerative commonly drowns out the concern for the welfare of the individual patient.
What relation does that conflict of interest have to the honesty in that role?
It leads to distortion, whether the distortion is willful, that is, whether it's truly dishonest, in which the person knowingly distorts information, misleads, or whether it's due to kidding yourself. You just see the good stuff and not the bad stuff, and you tend to suppress in your own mind bad things that are going on. So whether it's willful dishonesty or self-delusion or it's impossible to know, and without knowing more details. But the bottom line is the same, that the patient gets deceived, gets misinformation, the FDA gets misinformation, journals get misleading information, and it generally results in a situation that's not good for the individual patient, the general public, and future possible users of that drug.
Okay. Do you have an opinion about whether ethical misconduct requires a state of mind to defraud or hurt somebody?
It does not.
We were talking about Dr. Khan and interpreting, evaluating radiological images. You remember that?
Yes, sir.
What concern, if any, is from what you saw was happening in the medical records and the deposition you talked about in your pre-file testimony? What concern was there about his licensure status?
My recollection is that he was not licensed to practice medicine in the state of Texas.
Well, what difference would that make?
He was interpreting images which affected the care of the patient, which seemed to me the practice of medicine.
I'm going to point something out to make sure you do understand. You testified a minute ago that it's the practice of medicine. I believe this is correct. You said it's the practice of medicine if it affects the decision-making of the patient.
Yes, sir.
You remember that?
Yes, sir.
So is there any difference between practice of medicine because it affects the decision-making of the patient and or practice of medicine because it reflects or affects the decision-making of the physician for the patient?
Well, I meant both, and I think interpreting of images, if it affected either decisions by the physician to stop treatment or continuing treatment or change treatment, or if it affected the willingness of the patient to continue or stop based on how the images were doing, both would be of concern.
Well, does it have to affect both in order to be the practice of medicine?
It's a tricky issue. I mean, the physician is the one who guides the treatment, and patients are typically dependent on physicians and vulnerable in cases like this, and commonly are heavily influenced by the physician's view. So I think the more important issue there is whether it's affecting the clinician's decisions and recommendations.
So if you have, I believe you did testify, you recognize there were some board-certified oncologists working at the Burzynski clinic.
Correct.
And they have some kind of relation to what the foreign medical graduates were doing there. Do you remember that?
Yes, sir.
Including, and Dr. Khan was one of those people, foreign medical graduates.
I believe so, I don't remember for certain.
Okay, so in the relation of the oncologist to the foreign medical graduates of the group, research associates, foreign medical graduates, do you have an opinion about whether the oncologist could authorize a foreign medical graduate to practice medicine at the clinic?
Objection outside the scope of Frost.
He had talked about the board certified oncologist and then the foreign medical graduates.
Well, I mean, there are a couple of answers to that. I mean, first, it appeared that Dr. Burzynski was making all the decisions anyway.
You just need to answer his question.
I'm sorry, could you repeat the question?
The question was, could the board, what is your opinion about whether the board certified oncologist could authorize the foreign medical graduates to practice medicine?
I don't think he has that authority.
Okay. Do you have an opinion about whether the foreign certified oncologist could authorize the foreign medical graduates to appear as if they're practicing medicine?
He would not have that authority.
Okay, what's the problem if they did something like that? What's the problem if they said, go ahead and do this and appear to be the practice of medicine?
Well, at the least there'd be a violation of state requirements or requiring a license for the practice of medicine, and those rules are there for a reason, to make sure that people had appropriate credentials and had passed criteria to get a license.
So what are the ethical considerations about this?
That the patient would not, that the patient's treatment would be by people who were not possibly qualified to take care of patients. And the patients might be falsely believing that they were being cared for by licensed physicians.
I'm going to refer to an article that was Respondents Exhibit 16. And if I may approach the witness so that it would be a lot easier to read rather than to pull it from their stuff.
I don't recall if that was covered during the cross, was it?
I didn't mention a single piece of medical literature from our exhibit, Your Honor, outside, so I will object outside the scope of Frost.
They talked about Dr. Burzynski's articles. This is one of Dr. Burzynski's articles. Respondents Exhibit 16. They asked about the articles and whether that represented that he had been successful in treating people. And
I think my questions were, I held up a list of his articles that he had written and asked him if he had read them, and his answer was not all of them.
The objections.
Thank you.
okay. If there is an article written by Dr. Burzynski,
Objection outside the scope of Frost.
I'm almost done with redirect. Okay. Do you have an opinion about whether articles such as the ones that were listed or referenced on Dr. Burzynski's websites that were part of what the FDA had pointed out in 2012? We were talking about the promotional marketing issue. Okay. Do you have an opinion about whether Dr. Burzynski had an ethical duty to reveal conflicts of interest regarding those articles?
Objection outside
To
the
the
scope of
public.
cross. Objection outside the scope of cross.
Your Honor, they talked about what was on the website, and this is what was on the
I
website.
believe Dr. Faust, when he was asked about the list, repeatedly said, when he asked him, had he read all of them, he said no, and it was none specifically identified.
Okay, you testified about you saw the little chart that was on the screen about the investigator, the sponsor, the FDA, and the clinician.
Yes, sir.
You remember that? Okay. So you testified about conflicts of interest related to those relationships.
Yes, sir.
So these kind of conflicts of interest, where do they have to be disclosed to the general public?
Objection outside the scope of cross.
I'm sorry,
Yes,
we can hear me, but nobody else can.
You can just do a thumbs up or a thumbs
But
down.
the problem is you keep asking about conflicts of interest. He didn't ask him about conflicts of interest. And you're redirecting on his cross. Yes, you have it in your pre-file, but you didn't ask him about the conflict of interest.
I'm not going to argue with you, Your Honor. I'm
regard
trying to
to
figure
the-
this out.
In regard to what you're.
In regard to the question you're asking, it wasn't covered in cross.
Excuse me 1 second. That's what this is all about. Get that in. Have him get it in.
Can we come with you? Can we come with you? Sure.
That's fine, it's fine.
Question?
Yeah,
Go.
Yes.
yeah, I passed it with you.
I have nothing further.
I can't talk.
You may read it.
No, because it may not be complete sentence. You wrote it for me. I just want to clarify a couple of things. Have you ever, in your long career in this area, responded to a letter, an inspection letter from the FDA?
I don't know if I personally responded, it might be the
I'm asking
institution.
whether you personally.
No.
And in the 10 years since I understood you retired about 10 years ago.
No, about a year and a half ago.
Okay. Well, let me make sure I understand. I may phrase that incorrectly, but from the IRB, you retired how many years ago?
It was somewhere between 5 and 10.
Since that time, have you done any consulting work for private, small clinics as opposed to large corporations or drug companies or universities?
I don't think so, no, ma'am.
Those are the only two questions I have. We, I'm sorry.
I have no further questions.
No further, Your Honor, thank you.
Then you are excused, Dr. Thomas. Thank you for coming in. Sorry.
We'll start at 9 in the morning.
Thank you.
I'll just remind you that you might want to get here early to work on exhibits in court for me.
Right, and again, remind you if you have any back witnesses that happen to wander in, make sure and let them know and let us know.
Good night.
Unless there's a problem in, this is also, we're going to use Arabic numbers and not Roman numeral numbers when we write our decision. Is there any problem?
We'll say volume Arabic number.
Never.
Yeah,
As
I'll
opposed-
change it, I'll change it.
Thank you, because it's like,
I had to go study, believe it or not, I had to go study before this trial.
I was joking.
I really did.
I think it just makes it a lot easier.
I agree.
to Arabic.
I agree.
All right, everybody, you're entitled to leave everything in here if you want to. We're going to lock the